County list for fresh filing item 1, BA 5484 of 2026.
The allegation is that the informant is Mahesh Kumar Saw. He was constructing well.
मनरेगा का
मनरेगा
पेमेंट
का, हाँ.
आप पॉइंट बताइए आपको बैकग्राउंड
Point is also कि I was posted as junior engineer and I मेरे हाथ से पैसा नहीं निकल रहा है. बाद में जब बैंक का पॉकेट जो उसमें टिक किया गया
उसमें भी ऐसे ही होता है.
फिर हमारे हाथ
आपका बैंक का पॉकेट आपका बैंक डिप किया गया and it turned red.
Yes.
कैसे?
वही है pink it turned pink. That's
how does it turn pink?
But
unless the money goes into your pocket.
But the money has not been received from my physical person.
You threw it ना रास्ता में फेंक दिए 1 किलोमीटर चेस करके आपको पकड़ा.
वही allegations.
तो
And there is no independent witness also.
कोई independent witness का ट्रैक नहीं जरूरत नहीं. कब से कस्टडी में है?
12/4/26.
चार्जशीट हो गया? कुछ कर नहीं सकते. चार्ज प्लेट होने के बाद आइए. BA number 5484 of 2026. The learned counsel for the parties are present. The learned counsel for the petitioner submits that in a case relating to charge sheet नहीं charge frame होने के बाद. In a case relating to draft of the petitioner is in custody since 12/4/2026. The petitioner was a junior engineer and there is an allegation that he had demanded money in connection with disbursement of amount relating to Manrega. The learned counsel submits that the petitioner that the money was not recovered from the petitioner. However, he has submitted that the charge sheet has not yet been submitted. The learned counsel for the opposite party has opposed the prayer for bail and has submitted that the petitioner ran away from the spot, threw the money on the way, and when he was apprehended, his pant was dipped in solution, he turned pink. He has also submitted that after hearing the learned counsel for the parties and considering the aforesaid submissions made by the learned counsel for the parties and the petitioner, and it appears that the due process for that was followed, and the clothes of the petitioner was washed in solution which turned pink. This court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after framing of charge. Mr. Counsel, there is an order of the division bench that the authorities cannot retain records for want of sanction. आपको मालूम है कि नहीं मालूम?
On the point of sanction.
Yes. Division bench में, I remember around 15-20 years back, there was a PIA in which lot of cases of vigilance PS were placed before in the PIA court, where the sanctions were wanting for years together. In that case, an order was passed that the matter regarding sanction is required to be disposed of in a particular manner and within some time. So you cannot, if your sanctioning authority is not conscious of the fact, so he will renew his prayer for bail for want of sanction.
Because we shall examine the issue. And we shall also
see, this is also happening, no? In order to, I have charge frame नहीं होगा जब तक sanction नहीं आएगा. Sanction लेके बैठ नहीं सकते. You can't do this.
We shall contemplate this issue. Deeply okay.
From date list for fresh filing item 1, ABA 3012 of 2026.
This matter relates to chit fund scam also. Also, I was paying for college time to file counter.
AB number 3012 of 2026. Counsel for the parties are present. The learned counsel for
CBI.
CBI. Praise for 2 weeks will be sufficient. Praise for understanding 2 weeks time to file accountability in this case. Along with antecedent report, criminal antecedent report of the petition. The materials collected during investigation as against the petition we produced before this court in suit. The case ID like all in investigation completed.
We have already filed charge sheet, Lordship. In this case, it's a typical case where he was released on bond, Lordship, and thereafter he has escaped, Lordship. He is not appearing. For all those facts, we want to bring it on. Lordship.
Post on 9th of July. The counter affidavit should be filed dated by 7th of July.
Item 2 BA 5035 or 2026.
Yes, please.
On behalf of format, please. Fire, page 21 starts at page 21, 419, 420, 467, 68, 471, and sections of.
Just a moment.
This is a matter of cryptocurrency violation. 19 crore is taken from the different investor. Until now, I have not paid any amount till now.
They may say 1,000 crores, even before I am submitting. Let's say this is second journey. Earlier,
Supreme Court withdrawal orders.
You move.
yes, but I'll argue after the opinion. Earlier,
I can selectively hear also. I've not even heard what you have said.
I'm
I
myself,
guess, you know,
I'm myself submitting this is second journey.
if 5 persons are speaking at a time, I can selectively hear only 1 person. So you don't need to worry about it. No order will be passed without your hearing and without recording your submissions.
It is the allegation is that there are 2 persons, petitioner and co-accused. Initially, the informant came in contact with this petitioner and started
You
inventing.
moved earlier.
Yes,
First, you show me that order.
Yes, yes, you will.
Then-
All the orders, along the order, Supreme Court also brought on record. First order starts at page 47.
Prati Shankar Kumar.
Yes.
Where is the first order?
Page 47.
40.
Both the accused persons moved before this honorable court. By way of separate bail applications, having similar contentions, similar allegations, and similar antecedents. Both 2 FIRs were both were named in both the FIRs. It was rejected by the court by order 2nd of December 24. Thereafter, this petitioner moved before Supreme Court. During pendency of application before Supreme Court, this was withdrawn. For the reason being, your leadership may come to page number 52.
Reason should be reflected from the court's order itself.
That is the
You have to show the reason from the court's order. I will not read anything more.
No, we withdrew it before Supreme Court for the reason.
After some arguments.
With liberty to take appropriate steps.
That's right.
Because during
That
pendency,
liberty is always there.
what had happened, that the co-accused whose bail application was rejected along with this petitioner, he was granted bail in second journey, which is at page 52. 52. So the
52. Okay. Let me just read this order. At that stage, what was the stage on 2/12/24?
On 2/12/24, charge sheet was submitted, but there was no progress in the trial. Subsequently,
Just a moment. When the charge was printed?
I have given entire details.
7/5/24.
Yes. Charge
7/5/24.
2024.
No, he said charge sheet was submitted on 2/12/24.
Charge sheet. Not to kindly see impugn order last page 56, doctor. Page 56. It has come in the impugn order.
7/5/24.
Date of framing charge is 7/5. Then how
7/5/24.
Yes.
20.
Yes. So your rejection order is
2/12/24.
2/12 after framing of charge.
After framing the charge.
Yes.
Thereafter, during pendency, no witness was examined till 18th of July 25, which is an extra file. It has been reflected in the order of honorable court. That status was called. The discharge has been framed, but prosecution has not produced any witness.
No, it is 11/2/26. 7 witnesses have been.
Somebody already
You know,
examined.
I'm that also. I'm placing the order of co-accused. As on date, with regard to status, that also I stated in my petition.
No, you just let me see
As-
the order of co-accused and what is the reason granted. Let us see.
Page 52 is the order of co-accused.
Yes. 52.
Page 52 and extra file. Current status I have stated as well as I have annexed also. And I brought printout of as on date from
No,
that.
I add that since on 18/7/25, no witnesses were examined, therefore it was enlarged. You withdrew the bail application from the Honorable Supreme Court on 5/1/26.
26.
But this fact was not brought to the notice of the Honorable Supreme Court. And now when you renewed your prayer for bail, by that time, out of 11 witnesses, 7 have already been examined.
7.
And what is the present status?
That today's status printout, it is the same. Fourth witness examined and fifth was examined in chief but not cross-examined. That is pending since February.
No, you
No
see the
cross-examined
impute order. Let
examination.
us see the impute order.
Yes or no? 7 is
Not
yet.
yet.
I am placing that also. It says
Always
that out of
different.
11, 7 is yet to be examined.
7 is yet to be examined.
Yes, sir.
Not examined yet.
All right.
It has
Page
written
fif-
as not examined.
Page
sir.
56.
Just please go down.
No, I am not concealing it. कुछ भी conceal नहीं कर रहा.
आपको बिना सुने रिजेक्ट कर सकते हैं. आपको बिना सुने अलाउ नहीं करते. इसलिए आप बैठे.
Page 56. Third column, number of prosecuted witness 11.
Not examined.
Not examined. Look, this order dated 11th of February 26. Thereafter, PW5 was examined in chief and discharged. He had not appeared for cross-examination till date. That is the order given to the leadership today.
On that day, why didn't you cross-examine?
He was discharged at some point. He had to come with certain documents. That also I have next note. This may see.
PW5 has been examined now.
I placed that also. I will brought on record.
What is the date on which he has been examined?
19th of May 2026. So after
Who is
February,
PW5?
PW5 note.
Must be an official witness.
He was deferred to the paucity of time. It has been recorded in the order.
Then what was the next date?
Next date was 11th of June 26. He did not appear. That is at page 50.
On one date he did not.
Then
Then what is the next date?
was
Tomorrow is the date.
Tomorrow is the date. He will appear.
Yes, sir.
He will appear. एक डेट जंप करने से क्या ग्राउंड है? आपका ट्रायल हम तुरंत कंक्लूड कर लेंगे ना
हाँ,
सारे
I am ready.
witness.
Yes.
Chल.
He always deferred.
That state cancel, not the informant. That state cancel. You are the fixed certain.
You are the informant.
I am
The state, you will produce the witnesses.
Direction will be given.
Expeditious trial is your right.
Last submission subject to consideration since not placing the order of co-accused only. The offences are 490.
I will not be appreciated.
Only one submission. With regard to
बहुत सीरियस है. क्रिप्टो करेंसी ना आपको समझ में आया होगा ना हमको अभी समझ में आने वाला है. How does it actually work? These cyber frauds, how does it actually work is something we need training. As a court also I can say that I need to be trained as to how does this work. Huge amount of involved, huge persons are involved. I will expedite you. Trial is on. 7 विटनेस बच रहे हैं, आपका ट्रायल कंक्लूड
ये भी तो देखिए 2.5 साल का स्टडी
हो जाएगा।
420 का मैक्सिमम पनिशमेंट कितना है?
आपका BNSS में कितना पनिशमेंट है फॉर दिस साइबर फ्रॉड?
सेक्शंस तो वही है 66 बी सी डी वो तो अवेलेबल है
467, 468 ये सब में
हाँ,
कितना
that-
पनिशमेंट
That is the उसमें तो भी लाइफ हो गई।
है ना? लाइक
एक चीज है
इसीलिए
That
एज ए काउंसिल आपको थोड़ा सा सबमिशन करने में केयरफुल रहना चाहिए कि आप सिर्फ 420 की बात करते हैं
क्यों
जिसमें लाइफ पनिशमेंट है, आप उसकी बात नहीं कर रहे हैं।
सिर्फ एक चीज
इट्स अ
सुनिए
वेरी सीरियस
एक
ऑफेंस।
चीज सुनिए ना ही एलिगेशन है नाइदर चार्जशीट से दैट आई हैव
तो
फोर
क्रॉसिंग
डेज
ट्राई
ऑफ
कर दीजिए, 2-4 चार्जेस आपका डिलीट हो जाए।
एग्जामिनेशन सो ये एलिगेशन में नहीं है कि हम कुछ फॉर्जरी किए हैं सब्जेक्ट टू कंसीडरेशन एलिगेशन में नहीं है कि हम कुछ फॉर्जरी किए हैं वो धोखाधड़ी किए हैं और पैसे
चार्ज गलत फ्रेम
नहीं चार्ज फ्रेम हुआ
He's the owner of the Orope company, members. Entire amount deposited in his account.
not
He also
let
transferred.
them show that I am owner from diary the
ये
leadership
नंबर
is reflecting or not
565 of 2026.
out of record should not
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the bail application of the petitioner was rejected through BA number 2850 of 2024, along with the bail of the co-accused, namely Amit Agarwal, in BA number 8031 of 2024.
just one
He submits that the petitioner moved before the Honorable Supreme Court in special leave to appeal within that criminal number 3142 of 2024, and after some argument, he withdrew the application. He was permitted to withdraw the application with liberty to take appropriate steps. This happened by order dated 5/1/2026. The learned counsel submits that the reason for withdrawal was, though it is not reflected from the order of withdrawal of the Honorable Supreme Court, however, the reason for withdrawal was that the co-accused Amit Agarwal है कि Jaiswal? Amit Jaiswal, Agarwal मत लिखिए। Amit Jaiswal was subsequently granted bail in BA number 3935 of 2025 by order dated 18/7/2025 on the ground that charge having been framed, but prosecution had not produced any witness. The learned counsel submits that the case of the petitioner is on identical footing. He has renewed his prayer for bail, and by the impugned order passed by the learned court, which is dated 11/2/2026, out of 11 charge sheeted witnesses, only 4 were examined. He has further submitted that thereafter PW5 was examined on 19/5/2026, but on account of paucity of time, the PW5 could not be cross-examined. However, PW5 did not appear for his cross-examination on the next date, that is 11/6/2026, and the prosecution is lingering the case. The next date in the case before the learned court is tomorrow.
1996
The charge was framed on 7/5/2020. He is in custody since
7/1/2020
7/1/2020.
paragraph
The learned counsel for the informant and the opposite party state. You are representing whom? State has vehemently opposed the prayer for bail and has submitted that the matter relates to cyber fraud, which is further relating to cryptocurrencies. And how much amount?
19 crore.
90.
190.
19 crores and odd was deposited in the account of the petitioner.
no
His submission, I am recording his submission. Only submission, I will not record a finding. And The prosecution is ready to produce the witnesses. And tomorrow also, PW5 will appear for cross-examination. Should I record it? ऐसे नहीं, आप सोच के बताइए. He will appear?
Yes, already.
Okay. After hearing the learned counsel for the parties and considering the seriousness of offence as alleged, the bail application of the petitioner was rejected on merits earlier, and the petitioner on 5/1/26 withdrew the SLP against the rejection of the bail order, and the trial is in progress. This court is not inclined to enlarge the petitioner on bail. So far as the bail order of co-accused is concerned, he was granted bail on 18/7/2025, as at that point of time, the prosecution witnesses were not being produced. The state is directed to ensure that the remaining witnesses are promptly produced before the court. The informant of the case is also present. The counsel for the state is directed to immediately communicate this order to the. किसको communicate करना होगा? Who is to be communicated? Whom will you communicate this order? SP. To the SP of the concerned district and also to the director post. एक चीज और लिखिए. There can be no doubt that the petitioner cannot be detained in jail and the prosecution, there can be no excuse for the prosecution for non-production of witnesses once the petitioner is in custody. ठीक?
Yes,
ये order आज upload करना है.
I'll send.
Some after 3 months or 3 months or 4 months, maybe of the
जिस दिन witness नहीं आए, आ जाइए. मैडम, जिस दिन witness नहीं आया अगर ये आ गए ना,
Yes,
your SP will be in the job. Right? कोई excuse नहीं होना चाहिए. 24 से आदमी जेल में है. मजाक नहीं बना के.
I inform Rakesh personally.
Okay.
Item 3, DA5038 of 2026.
May I please?
Yes.
FIR in this case has been issued under section 69 of the BNS. There is allegation in the FIR that this petitioner established physical relationship by on pretext of marriage.
Custody.
Custody 15/1/26. Both victim and the petitioners are major, and there is delay of 45 days in lodging of FIR. I have no criminal acts. They were in friendship relationship, but during talks, daily talks, some
The counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit in this case. Charge हो गया आपका? Charge sheet.
तो इसके बारे में इंस्ट्रक्शन नहीं है मैम, लेकिन हो गया।
बेसिक इंस्ट्रक्शन ही नहीं रहता. कस्टडी कब से?
15/1/26।
वही भी आप.
हाँ जी।
Let the case diary be called for from the concerned court along with the medical examination report of the victim and also the statement recorded under section 183 BNS. The counter affidavit be filed by 13th of July, post on 14th. यहाँ फाइल कर देंगे. मेरे पास कोर्ट में जब फाइल करते हैं तो मेरे पास फाइल में नहीं आता ना रात को. कोर्ट से परमिशन लेके एक दिन पहले काउंटर एफिडेविट फाइल करते हैं.
Item 4, DA.18.06.2026.
Yes, Krishna.
Please.
Yes.
Section 82, 85 and 3/5 of the BMS. The petitioner is the husband of the deceased. Now,
Date
during
of marriage.
course-
Date of marriage.
date of marriage is sometime in April 2024.
Date of death.
Date of death is
12,
20/12/2025. 20/12/2025.
2025. Death कहाँ पे हुआ?
Death matrimonial.
Any allegation of dowry?
Lords, during course of investigation,
Any allegation of dowry? in the
well,
FIR?
in the FIR it is.
Yes. Postmortem report.
Postmortem report is asphyxia due to hanging. It is a
Where is the
case of
postmortem?
suicide.
Report कहाँ?
Report हमारे पास तो नहीं. And during investigation, several witnesses have been examined. They have not supported the case of the demand of dowry. They have stated कि domestic issues को लेके आपस में altercation था. That has come in the charge sheet also, page 21, if your lordship can kindly have a look. And it has also come that at the time of alleged incidents, this petitioner was on duty in his bank. That has also come.
Since from presumption of the affair, it is stated not that the allegation of demand of dowry is there. The informant is the father and father. He has supported his case during investigation. The other persons are the other relatives. They could not have been given the entire details. And prior to her death, 9 months ago, there was a occurrence of assault over the deceased, and for which there was a sitting between different families regarding the dowry plots.
She gave birth to the child or not? She gave birth to the
Yes,
child or not?
3 months. 3 months. First time it was aborted, but again she considered that there was 3 months child loss at the time of his death, of her death.
The number 5040 of 20.
Your lordship may kindly have a look to page 21 first. The finding of the IO in the charge sheet. And I would request, my lords, that the case diary would be necessary, if your lordship so pleases, my lords. Page 21. कांड में अब तक के अनुसंधान घटनास्थल के निरीक्षण वादी और साक्षियों का बयान तथा प्रवीक्षण से ये कांड धारा 100 के अंतर्गत प्राथमिकी अभियुक्त 100 के विरुद्ध सत्य पाया गया। अनुसंधान के क्रम में वादी एवं साक्षियों का बयान दर्ज किया गया। घटनास्थल के आसपास के स्वतंत्र साक्षियों का बयान दर्ज किया गया है। वादी एवं साक्षियों के बयान से यह बात प्रकाश में आई है कि वादी कृष्णाराम के द्वारा अप्रैल 2024 में अभियुक्त 100 के साथ 5 लाख रुपया नगद और करीब 3 लाख का घरेलू सामान लेकर किया गया था। वादी पक्ष के लोगों द्वारा बताया गया कि शादी के कुछ दिन ठीक रहने के बाद मृतका सत्या कुमारी की सास बबीता देवी, ससुर अवध किशोर राम बबलू के द्वारा मृतका सत्या कुमारी को लगातार प्रताड़ित करने लगे एवं स्वतंत्र साक्षियों द्वारा इस बात का खंडन किया गया है। अनुसंधान के दौरान पता चला कि घटना के करीब 9 माह पहले दोनों पक्षों के बीच में लड़ाई झगड़ा को लेकर आपस में पंचायत भी हुई, जिसमें दोनों पक्षों के लोगों ने लड़का लड़की को भविष्य में अच्छे से रहने के लिए बोला था, जिसमें दोनों लोग राजी हुए थे। अनुसंधान के दौरान घटना के दिन अभियुक्त बबीता देवी और अवध किशोर राम दोनों अभियुक्त रांची इलाज कराने गए थे और मृतिका का पति प्रीतम कुमार चंदन अपने ICICI बैंक डोल ब्रांच में होने की बात अनुसंधान के दौरान आई है। अनुसंधान के दौरान मृतिका का अंतर परीक्षण रिपोर्ट प्राप्त है, जिसमें कॉज ऑफ डेथ एस्फिक्सिया ड्यू टू एंटीमॉर्टम हैंगिंग बताया गया। कांड के अनुसंधान में सुएंस Now, lords, during the course of investigation, the witnesses have stated कि domestic issues पे झगड़ा झंझट होता था, for which there was a पंचायती और दोनों पक्ष बोला था कि अब से ठीक से रहे। And it is a case of suicide as per the postmortem report. And In the post-mortem report, my lords, no injuries were found on the deceased. That has also come. So diary is necessary, my lords, because several
Even if-
things.
Even if she commits suicide in matrimonial home, and there is a torture regarding demand of dowry.
That has not been supported by the witnesses. Therefore, I was placing.
Who will be a witness to torture of dowry?
My lords,
Only the family members would be a witness. Normally,
तो-
पड़ोसी लोग ये सब चीज के witness नहीं हैं.
death के बाद अगर आके कहते हैं कि doubt. But prior to that, what they are saying that there was a panchayati, but in the panchayati there was no issue of doubt.
We do not know.
It has come during
पंचायती का कोई
investigation.
document आया है? Is there any document on panchayati?
Document they have also not
So
produced.
therefore,
So, but the witnesses who were present in the panchayati, they have stated so. They have stated so that there was no such demand. और पंचायती डिमांड ऑफ डाउरी और टॉर्चर के लिए नहीं हुआ था.
तो ये सुसाइड क्यों कर रहे?
सुसाइड जो की है तो देयर शुड बी सम नेक्सस
Pregnant
बिटवीन.
lady committing suicide.
Eh?
A pregnant lady committing suicide.
Not a pregnant.
नहीं ये false summation है. She
नहीं, हम
was
नहीं
not
बोले कि हम
pregnant.
pregnant है, हम बोले कि
नहीं आप
on the
बोले कि
first-
3 महीने
On
की
the
pregnant
first
थी.
time she was aborted, and then again she conceived and she
With
gave
9
up.
months
But
of-
3
she
months
was-
baby, 3 months baby was there.
She was not pregnant
No, she
at
was
the
not
time
pregnant
of.
at the first.
Yeah.
Initially there was she conceived. Her pregnancy was aborted. She again conceived and then she gave birth to a child. It was 3 months aged at the time of
आपके
death.
पास केस डायरी आया है?
At the time of death, the lady was having a 3 months child.
ठीक है केस डायरी मंगा लो. कब तक प्रोड्यूस कर देंगे? कहाँ का मैटर? The learned counsel for the state is directed to file a counter affidavit in this case. Let the case diary be called for from the concerned court, along with its enclosure, particularly post-mortem report and the inquest report. Stage, yeah,
Stage
Charge is
come. Charge is yet to be framed. What
along with the present stage of the case. Post on 14 July. The counter affidavit will be
14
filed
July.
by 13.
14 July.
Item 5, BA 5042 of 2026.
The offense under 669 of BNS and 4 of POCSO. Now, my lords, may kindly have a look to the first information report, which is at page 11.
Age of victims.
Age of victim is 17 years, as per her disclosure.
You must be knowing the age. Are you aware? Are you aware of the age which has been found?
If I
in
have,
the
then she has disclosed.
during investigation, any different data?
Because the diary is not available with us because it is a case of POCSO, my lords, date records are not given to us initially. Unless the paper book is supplied. The impugn order is also very cryptic, no discussion about medical report.
You are 35 years of age.
No,
You are
35.
35.
हाँ, yes.
Age gap भी बहुत है. कोई adolescence love affair का कहानी नहीं.
हाँ, वो नहीं. That is not there, but your lordships may kindly consider
The
the
council for the state is directed to serve notice upon the involvement of the case and file a counter affidavit in this case. Let the case diary be called for from the concerned court along with the statement of the victim recorded under section 183 BNSS and also her medical examination report. FSI they have put
I don't.
post on 14 July. Counter affidavit should be filed by 30 days.
Item 6, BA 5044 of 2026.
Case of cyber crime with the first time matter registered. This may be tagged with plus 4991 26 months. 4991 public 26
Oh,
26
what is the date fixed?
7 July 26.
BA number 5044 of 26. Counsel for the parties are present. The counsel for the petition submits that arising out of the same FIR, BA number 4991 of 26 has been posted on 7/7/26, in which case ID has been called for. The counsel for the state, and he submits that this case be tagged along with 4991 of 26. The learned counsel for the state is directed to seek instructions and file a contract affidavit with regard to the criminal antecedent report of the petitioner, with particular reference to the investigation to the criminal antecedent of the petitioner with respect to any other case registered in the state of Jharkhand or in any other state, with particular reference to the information collected during investigation and the complaints reflecting in the post on 7/7/26, tagged with 4991 of 26.
Item 7, BA 5049 of 2026.
Ready for Passover?
Just solve.
Item 8, BA 5050 of 2026.
Passover.
Item 9, BA 5054 of 2026.
At the very outset, I should point out the BA number 4337 of 2026, wherein by order dated 11th June 2026, test ID has been called for, arising out of the same case, and it has been fixed on 7th July 2026.
BA number 5054 of 26, the learned counsel for the petitioner submits that the case of the court case being BA number 4337 of 26 is fixed on 7/7/2026, in which case ID has been called for. The learned counsel for the petitioner submits that the case be tagged and placed on the same day. Considering the submissions, let this case be tagged with BA number 4337 of 2026 and posted on 7/7/2026. आपको तो कुछ करना नहीं. The counsel for the state shall seek instructions and file counter affidavit. इतना तो कर दो. Along with antecedent report of the petitioner. अगला डेट में काउंटर के लिए हम टाइम नहीं देंगे, बता दे रहे हैं आपके बेनिफिट के लिए.
Item 10, BA 5056 of 2026.
Case is under section 69 of the BNS. It is alleged or said that both are major lordship and they are working in chap lots. The allegation is that on the pretext of marriage, the petitioner established physical relationship, and thereafter further allegation that he has taken 7 lakhs rupees to the informant on several occasions. They have returned to 6 lakhs rupees.
Informant कौन है?
I am important. No, not see. case, Lord say, there is a delay. There is a delay of 3 years in lodging in the FIR, Lord say. Now, it appears from the FIR itself, Lord say, that there are consensual relationship between both the parties, Lord say. And no such specific date or occasion on which that he has established.
10/3/36 is your custody.
Yes, Lord.
26.
Charge sheet has been submitted. And now, Lord, the informant is the age of more than 40 years. Petitioner is unmarried, he is 30 years old, Lord. And the lady is a mother of 3 children, Lord.
So you
Now,
cannot
so far the money.
there is no, the relationship is not arising out of any promise to marriage.
Yes, Lord, that.
Mother of 3 child, how will she give a promise to marriage?
Widow mother of. Widow. Is getting job in the place of husband. And now last part.
Let us see the FIR.
Yes, Lord. Page 22. May I read, Lord?
Yes. Don't take the name, please.
Yes, Lord. स्वामी में निवेदन पूरा करना है कि मैं लिपिक सचिन सच झारखंड पुलिस सहायक में विगत 7 वर्षों से कार्यरत हूँ। पिटिशनर जो कि वर्ष 23 में झारखंड पुलिस लेखापाल प्रधान लिपिक सहायता के द्वारा मुझे बार-बार मैसेज फोन किया जाता था। बार-बार वो मुझसे बोलते थे कि मैं आपको बहुत पसंद करता हूँ, मुझे बहुत अच्छी लगती हैं, आप मुझसे प्यार हो गया है। मैं इन बातों को सुनकर फोन कट कर देते थे। जब हम बोलते थे कि ये सब पसंद नहीं है, मुझे फोन मत कीजिए, वीडियो कॉल करते थे और चाकू से नाक काटने की धमकी देता था। कहता था कि नाक से जान मार दूंगा, एक नोट में लिख दूंगा, मेरी मौत का जिम्मेदार है और आपके ऊपर केस हो जाएगा, कहीं नहीं रहेगा, क्योंकि मैं बड़ा भाऊ हूँ, तो चाहे कोर्ट में आपको निलंबित करवा सकता हूँ। आप मुझसे बात करिए, मैं बदनाम कर दूँ, क्योंकि मैं बड़ा भाऊ हूँ। सब लोग मेरे यहाँ बात मानने इस वजह से मैं उनसे बात करने लगी। अलग मेरे लिए अलग नंबर रखते थे, सचिन सर थे, मुझे हमेशा बोलते थे कि मेरी बात मान लीजिए तो मैं आपको परेशान करेंगे। फिर मैं डर से बात करने लगी। पिटिशनर बोला कि मैं आपसे बहुत प्यार करता हूँ, मैं कभी नहीं धोखा दूंगा, मैं किसी और से शादी नहीं करूँगा, मैं आपसे शादी करना चाहता हूँ। मैं हमेशा उसे मना करती थी, मेरे 3 बच्चे हैं, आप कुंवारे हैं, आप कहीं और शादी कर लीजिए। तो वो बार बार अपनी माँ कसम खाकर कहता हूँ मैं आपसे शादी करूँगा, नहीं तो नहीं करूँगा, आपके बच्चे मेरे बच्चे हैं, फिर भी हम नहीं माने। अचानक ऑफिस में बात हुआ कि पिटिशनर शादी कर लिया है, आपसे शादी तो आपने शादी कर लिया है। मैं अपने माँ की कसम खाने को बोला तो वो सब झूठ है, मैं सिर्फ आपसे शादी करूँगा। नवंबर 25 में उसने मुझे धमकी देकर मंदिर में बुलाया। मुझसे शादी करने के बाद मैंने मना किया तो बोला पर्टिकुलर हो जाऊंगा, मुझसे शादी कर लो। तो वो बोली सब लोग कहते हैं कि आपने शादी कर लिया, गाँव में यह सच है? तो बोला नहीं, मैं भगवान की कसम खाता हूँ, मैं अपनी माँ की कसम खाता हूँ, मैंने किसी से शादी नहीं की है। उसने मेरे मांग में सिंदूर भरकर मुझसे शादी कर लिया। मुझसे शादी से एक मोबाइल फोटो खींचा है, उस फोटो से हटाने के लिए कहा, नहीं हटाई। अचानक एक दिन इंस्टाग्राम पर अपनी आईडी में मोहन रजक ने शादी का फोटो अपलोड किया तो देखा कि रानी के साथ शादी का रिवाज दिख रहा है। मैंने स्क्रीनशॉट लेकर उसे मैसेज भेजा, पूछा क्या है, तो बोला मेरी भाभी है। मैं अपनी रानी से पूछा कि पिटिशनर कौन है, तो आपको, तो उसने कहा कि मेरा पति है। इस तरह पिटिशनर ने मुझसे शादी का धोखा दिया। वर्ष 23 से मेरा मानसिक शारीरिक आर्थिक शोषण किया तथा पिटिशनर ने मुझे भागलपुर ले गए थे, वहाँ मेरे साथ शारीरिक संबंध बनाया था और पिटिशनर ने कैश में 7 लाख रुपया अपना ट्यूमर, माँ के कैंसर पीड़ित थे, उनका इलाज कराना।
What do you want to say? You are major consensual relationship.
On pretext of marriage ये हमसे शादी भी किए थे, उसका फोटोग्राफ भी आया केस डायरी में। ये हमसे शादी भी कर लिए, ये बात छुपा के कि ये कहीं और भी शादी करी। और उसके बाद शादी करने के बाद जब हमको पता चला तो हम इनसे पूछे।
ठीक है ना, वो तो आप ट्रायल में देखेंगे क्या इन्होंने किया क्या नहीं किया। बेल का केस तो बनता है। चार्जशीट हो चुका है।
85 ये हमसे 7 लाख रुपया में ये जो एडमिटेड है जो केस डायरी में
और लौटा भी दी
उसमें से 6 लाख लौटा है, 1 लाख नहीं लौटा। 1 लाख अप्रैल 2026 में लौटाने के बाद था
अब
जो
लौटाए नहीं अभी तक।
नहीं लौटा।
1 लाख 1 लाख
FIR ही हम देख लिए 1 लाख कैश दिए हैं, अभी जो बोले लौटाए हम FIR ही देख लिया जाए कि 6 लाख रुपया रिटर्न कर दिए
6 लाख दिए, 1
हम
लाख
1 लाख रुपए कैश भी दे दे रहे हैं।
1 लाख
में तो सारा पैसा कैश में देते हम तो अकाउंट में दिए 6 और एक कैश में दिए और FIR में लिख रहे हैं कि हम लौटा दिए 6 लाख
नहीं
6 लाख लौटा दिए हैं।
हाँ,
1 लाख
1 लाख नहीं लौटा है। हैंड रिटेन नोट्स है इनका इसमें सिग्नेचर किया है। ये खुद बोले कि अप्रैल 2026 में लौटाएंगे, लेकिन ये कस्टडी में मार्च है।
कैसे कैश लौटा
हम दे देंगे हुजूर, लेकिन हुजूर देखा जाए FIR का हम लास्ट पार्ट पढ़ते हैं, बैंक की स्टेटमेंट है पिटिशनर का लिखा हुआ मेरे पास 7 लाख में से 6 लाख वापस किया, वो हम लिखा हुआ कि 6 लाख वापस किए, 1 लाख ही बोलते हैं कि नहीं लौटाए हैं। फिर हम कैश दिए थे, फिर भी उसका तो मेरे पास भी प्रूफ नहीं है, अगर बोलेंगे हुजूर तो हम लौटा देंगे, बट हम सारा पैसा रिटर्न कर दिया, माँ के ट्रीटमेंट के लिए लिए थे हम वो वापस भी कर दिए।
इम्प्यून ऑर्डर
जो फोटो बोल रहे हैं हुजूर जो आया है फोटो
इम्प्यून है ऑर्डर रनिंग पेज 3 माय लॉर्ड, इसमें आया
हम
है
लिखे कि आप अपने इंस्ट्रक्शन से बोल रहे हैं कि 1 लाख रुपए लौटा
हम
देंगे।
लिखे
दोनों बात नहीं चलेगा ना।
6 लाख तो ऑलरेडी दैट हैज एडमिट की हम लौटा दिए, 1 लाख के बारे में हम लिखे हैं
क्या कि वो भी वापस
कर दिए।
कस्टडी कब से?
स्टडी 10/3/2026
चार्जशीट सबमिटेड
चार्जशीट has been submitted.
for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. The victim is a widow having 3 children and who was working in the same office in which the petitioner was working. And as per the allegation itself, there was consensual relationship between them, but the victim has alleged that the relationship was established on the pretext of marriage. And she was called by him to a temple, and there he put vermilion on her head, and a photograph was also made by him. However, she came to know that the petitioner had already married another person. Further allegation is that the petitioner had taken 7 lakhs for the treatment of his mother from the victim, and 6 lakhs was returned to her, 1 lakh was pending to be returned. He submits that the victim is 40 years of age,
More than 40.
more than 40 years of age, and the petitioner is 30 years of age. He is in custody since 10/3/2026. The learned counsel for the informant has opposed the prayer for bail and has submitted that the allegations are very serious, and on the pretext of marriage, the victim has been, the petitioner has established physical relationship. He has also submitted that remaining 1 lakh rupees has not yet been returned. To this, the counsel for the petitioner submits that he has returned rupees 1 lakh in cash. And there is a dispute as to whether rupees 1 lakh has been ultimately returned to the victim or not. After hearing the learned counsel for the parties and considering the fact that there appears to be some element of consensus with respect to the relationship between the parties who were working in the same office, the petitioner is in custody since 10/3/2026 and charge sheet has already been submitted. The petitioner is dedicated to be in custody. ऐसा कोई कंडीशन हम नहीं लगाएंगे पैसा देने के लिए, पैसा का लेन देन का कंडीशन हम नहीं लगाएंगे। आप तो आपस में समझिए क्या करें।
Item 11, BA 5057 of 2026.
was a few cases.
अच्छा.
Item 12, BA 5059 of 2026.
Outside leadership in the diary would be required because initially FIR was lodged in section 96 alleging enticement. Subsequently, from June order it is clear that charge sheet has been submitted under 96 and 64 of BNS and 46 of POCSO Act. The victim
Council further state the directive to serve notice upon the victim and file a counter affidavit in this case. Let the case directive be called for from the concerned court along with the statement of the victim recorded under section 183 BNSS. Along with its enclosure we include that, and also the statement of the victim recorded under section 183 BNSS. Post this case on 7th of July. The counter affidavit should be filed latest by 6th of July. From the victim. With antecedent report.
Item 13, BA 5068 of 2026.
Offense under section 3025 PC, Your Lordship. I permit to read the FIR, Your Lordship.
Are you named in the file?
Yes, Your Lordship.
Who are you?
I am the husband of the deceased.
I'll read the FIR. Please give me some details. What is the date of death? Date of marriage?
I have not mentioned in the FIR as by mistake.
You are not aware. What is the date of death?
10/11/2022. In the year 2022, she died.
And since when are you in custody?
I'm in custody, Your Lordship. In 23/11/2022.
23,
11,
11, 24. Where were you for 3 years?
in custody.
No, from 10, 11, 20. आपकी वाइफ मर गई है 3 साल से कहाँ थे?
2022 में मौत हुई थी और मैं
कस्टडी है 23/11/25 से
23/11/22
22 से आप कस्टडी
जी
क्या चल रहा है केस में?
ये इंफॉर्मेंट का गवाही जिन्होंने एफआईआर का उनका गवाही हो चुका है P5 शी हैज बीन डिक्लेयर्ड हॉस्टाइल
और कितने गवाह बाकी हैं?
अभी 4 गवाह और बाकी
कहाँ से बोल रहे हैं? How many total witnesses are there?
इसमें लिखा है एविडेंस में पीछे ऑर्डर पेज नंबर 26 देखा जाए रिक्वेस्ट ऑर्डर
2024 का इंक्लूड ऑर्डर
तो इस पे स्टेज दिया हुआ है
2024 का स्टेज से आज बेल होगा आपका?
नहीं तो नहीं
तो फिर
नहीं तो स्टेज दे दिया है कि स्टेज क्या था विड्रॉ किया था एलियर पहले कोऑर्डिनेट बेंच से क्या विड्रॉ किया था
कौन से बेंच से विड्रॉ किया?
कोऑर्डिनेट बेंच है जस्टिस फॉर्मर जस्टिस अंबुजा साहब को उसने विड्रॉ किया था
स्टेज क्या है केस का? 2024 का इंक्लूड ऑर्डर लेके 2026 में आप thereafter you did not move again.
There I moved but it was
No, you are not moved after the withdrawal of the case.
No, I moved but it was dismissed for default for non-compliance for non-removal defect.
So that has to be restored. A fresh bail application कैसे फाइल करेंगे?
For dismissed that's why I filed the fresh bail.
No. कैसे हो? एक केस में एक भाई आप एक कोर्ट में बेल फाइल के डीएफडी हो गए उसको रिस्टोर कराएंगे ना?
दो ऑप्शन होते हैं क्या
दो ऑप्शन नहीं होते हैं क्योंकि जब फ्रेश बेल फाइल
करेंगे नंबर नहीं पड़ा था तो फाइलिंग नंबर था बस
एक ही बात है दो ऑप्शन नहीं होते हैं बेल एप्लीकेशन रिस्टोर कराना पड़ता है
I didn't I मेरे पास सर्टिफाइड कॉपी से मैंने फ्रेश बेल फाइल जब तक आता तब तक डीएफडी हो चुका था इसलिए मैंने फ्रेश बेल फाइल किया
ऐसा नहीं हो सकता इसका रीजन है आपको बताती हूँ अभी तो सेम बेंच है बेंच चेंज हो सकता है तब आप बोलेंगे डीएफडी हो गया तो टाइड अप नहीं सब कहानी नहीं चलेगा रिस्टोर होगा That is also an order of dismissal. May be dismissed for default. That is also an order for dismissal.
सुन लिया था 4 साल से कस्टडी में है सुन लिया और इन्फॉर्मेट
4 साल से कस्टडी में है, लेकिन आप तो 2024 का इम्प्यूट ऑर्डर लगाए हुए हैं। स्टेज क्या है केस का?
एविडेंस में है
वो तो
मतलब 7
कितने
गवाह
विटनेसेस हैं? हाउ मेनी विटनेसेस?
11 विटनेसेस 7 हो चुके हैं।
कहाँ से बोल रहे हैं?
मेरे पास फोटो कॉपी है विटनेस डिपोजिशन का।
कब हुआ लास्ट एग्जाम?
लास्ट एग्जामिनेशन हुआ था Of 23rd April 2026.
23/11/2026 2026 आ गया?
23 April 2026.
How many witnesses are left to be examined?
Sorry, my mistake. 9 witnesses हो चुके, 2 witnesses are examined.
एग्जामिन करा? नेक्स्ट डेट बताइए। नेक्स्ट डेट बताइए।
नेक्स्ट डेट हम आपकी
कोई बात नहीं। BA number 5068 of 2026. Or the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is the husband of the victim and he is in who died in matrimonial home by unnatural death. And he is in custody since 23/11/2022. The counsel is not aware about the date of marriage. He submits that the bail application of the petitioner was dismissed as withdrawn by order dated 11/2025 in BA number 10225 of 2024. Thereafter, another bail application was filed, being BA filing number 21156 of 2025, which was dismissed for default on account of non-removal of defects in terms of order dated 17/4/2026. He submits that the order dated 17/4/2026 was passed by this bench itself. Instead of filing any restoration application to the BA, a fresh bail application has been filed. Although the petitioner ought to have filed restoration application. The learned counsel further submits that, considering the custody of the petitioner may be enlarged on bail. The impugned order is dated 6/9/2024, and upon a query of this court, the learned counsel for the petitioner has submitted that only 2 witnesses are remaining to be examined. Next date.
7th July.
7 July is the next date.
Next date, no.
He is not aware about the next date in that time. Counsel for the state has opposed the prayer for bail.
One submission will be recorded. P-double-5 has been declared hostile.
The learned counsel has also submitted that P-double-5 has been declared hostile. After hearing the learned counsel for the parties and considering the fact that bail application of the petitioner was withdrawn earlier by a bench who is not available, and the trial is at fag end. Accordingly, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The learned counsel for the state is directed to ensure that it is directed to communicate this order to the SP of the concerned district and to the Director Prosecution for compliance.
Item 14, DT.18.07.2026. of 2026.
Kaso.
Item 15 PA 5074 of 2026.
Under section 64(1) of DNS and section 4 of POCSO Act.
Trial is on. Trial is on.
Yes, victim has been examined as PW1.
Yes, sir, last time.
No, she has supported that. Page number 19 is done.
How many witnesses have been examined?
As per the review order, 7 witnesses are there, 1 has been examined.
Let me see that.
Page number 19.
Internal page?
Computer.
Yes.
And internal page 24, on which it has been stated that just 6 lines from the bottom. Column number 13 of charge sheet contains names of 7 prosecution witnesses to be examined into the matter. The victim heard in a statement recorded in section 183 of the BNSS has fully supported her allegation of forceful rape committed by this petitioner against her will without making any observation at this stage in writing in order to such. And subsequently, she has been examined as
So
PW1.
where do I get how many witnesses have been examined? You said that only 1 witness out of 7 have been examined.
Out of yes, PW1 is the victim herself.
Where is the statement? Out of how many witnesses are remaining to be examined?
Statement.
You said that only 1 has been examined so far.
1 has been examined.
Where
It
do
has
I
been
get
examined
this?
on 15th of May 2026.
If she has supported the case, then how are you entitled to?
Yes,
bail?
registered January.
Sorry,
January. Case registered January 8/1/26.
26 का case.
26.
26 का. There are few.
26 का case है, trial is on.
Trial is on.
एकदम act के अनुसार 6 महीना में खत्म.
PW1 and victim has also already been. Only point that you there was delay of 11 days in the FIR. Occurrence took place inside the house. Nobody came and she did not make any alarm or shouted for help. The inhabitants of the house, they have not been made witness in this case and they have not. But victim has supported in her 183 statement as well as in her deposition. And age is between 17 to 18.
Age of the petitioner, Your Lordship, 45 months.
For the learned participating on behalf of the parties. The petitioner is 45 years. Is in custody since
Custody
9/1/2026.
9/1/2026. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and there is a delay of 11 days in lodging the FIR. The age of the victim is 17 to 18 years. We have submitted that victim has been examined as PW1 and she has supported the case, but the trial has not concluded so far. Out of 7 witnesses, only 1 witness has been examined. The learned counsel for the state has submitted that. The case is of January 2026 and trial is in progress. There is direct allegation against the petitioner and accordingly the petitioner may not be enlarged on bail. after hearing the learned counsel for the parties and considering the allegation and the trial is already in progress, that this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are confused. 2 महीना में खत्म करेंगे। काफी नहीं है 2 महीने।
लॉर्डशिप पेज नंबर 21 में तब आया स्टेटमेंट कि फर्दर पहले भी इस तरह से घटना घटी। पेज नंबर 21 में पारा 20 में स्टेटमेंट है विक्टिम।
Item 16 BA 5075 of 2026.
Yes, petitioner.
Yes, it's a case of cyber offense for the statement.
You have an antecedent.
Yes.
Is it cyber offense का ही antecedent?
That is.
Charge
that instruction.
कब से custody?
Yes, custody since on almost for 2 months, 25th of April 2000.
Charge के होने के बाद।
In order to see, but there is no reason that we whether there is a victim or that in the
No victim has been identified.
in the in order no recovery is there and that
False promise of lottery.
that is the reason.
Consumer the state is directed to call on, is directed to file a counter affidavit in this case, along with the criminal antecedent report of the petitioner, indicating as to whether any case has been registered, any other case has been registered in the state of Jharkhand or in any other state, depending upon the material collected during the investigation and the complaints reflecting in the portal. The state is also directed to produce the up-to-date case diary. The petitioner is in custody since 25/4/26. The learned counsel submits that if the matter is posted after some time, the charge sheet may be submitted against the petitioner so that the case, so that the materials collected during investigation may be taken, may be considered. कब रखें बताइए? 25 चार से डेट बताइए किस दिन रखें? 25 चार से तो 7 के बाद
25 7 के बाद 28 को
at his request the matter is directed to be posted on 29th of July. The counter affidavit be filed by 27th of July. The counsel for the state is directed to submit the case diary to the learned court master on 27th.
Item 17 BA 5083 of 2026.
Sorry?
मोबाइल वाली नो क्रिमिनल एक विक्टिम है अयार नायक एक
Investigation is at primary stage. तो अभी कैसे पता चलेगा कितना victim?
हाँ उसके लिए नहीं लेकिन एक ऑर्डर से आया
हम लोग इतना जल्दी मूव कर लेते हैं इन्वेस्टिगेशन होने शुरू होने के पहले ही मूव कर लेते हैं
हम लोग के ऊपर दबाव आता है इसलिए
लेकिन आप देखिए अभी इन्वेस्टिगेशन ऑन है इस स्टेज में हम किसी ग्राउंड पे रिजेक्ट कर देते हैं 1 मंथ कैसे तो 29 स्टार्ट का है 3 महीना बाद है ना चार्जशीट होगा तो इसका जो
29/7 तक हो जाए, 1 महीने
29/7 तक तो आपका चार्जशीट होगा, उसके बाद ही रखिए। ये नंबर 5083 ऑफ 2026 सेम ऑर्डर करेंगे पंकज, अभी जो प्रीवियस ऑर्डर किए। इनका कस्टडी है 29/4/26 से है, ठीक है। At his request or the counsel for the petitioner के request पर, ठीक है। The matter is directed to be posted on 5th of August. The counter affidavit should be filed by 3rd of August and the case diary be submitted to the learned court with enclosures. 3 तारीख को केस डायरी जमा कर देंगे यहाँ कोर्ट में, पूरा इन्वेस्टिगेशन के साथ। और पोर्टल में आपका जितना आ रहा है ना कंप्लेंट, सब में हम ऑर्डर कर रहे हैं। FIR है कि नहीं है आपको पता?
एक कंप्लेंट है इस पे आया।
कंप्लेंट एक बात है, FIR है कि नहीं दूसरी बात है। FIR रजिस्ट्रेशन दूसरे स्टेट से आ रहा है, FIR रजिस्टर्ड है कि नहीं दूसरी बात।
एक मैडम का हम विड्रॉ किए थे, एक उसमें एक इंसिडेंट था, दिल्ली का केस था, तो दिल्ली गया वहाँ तो हम उसको पैसा जमा करा के CGM में
बहुत अच्छा बात है। आप दिल्ली
अब उसको लगा कम फाइल कर
पूरा क्या लगा क्या फाइल करने में
या फिर सेकंड बिल पिटीशन फाइल करेगा ना या डिसमिस हो गया
तो किसको उसी को वहां से बेल हो गया है,
उसी केस कंप्लेंट होगा हम उससे बेल
वही से अब दिल्ली से ही होगा, सुप्रीम कोर्ट से होगा, कहां से होगा?
CGM क्या है 30,000 कोर्ट से वो गया, वो पैसा जमा किया 14 तक जमा किया उसी समय दे दिया।
हम लोग उतना फास्ट फॉरवर्ड नहीं है, स्लो। आप लोग की तरह स्पीड हम लोग तो नहीं। और वैसे भी जामताड़ा झारखंड में ही पड़ता है,
केवल बदनाम हो गया बस,
केवल बदनाम जी। अब नया आप लोग का क्लाइंट जेल से निकलता है, सेम ऑफेंस करता है। अभी नया क्रिप्टो करेंसी चला हुआ है और भी चला हुआ है,
दूसरा कोई काम
निकलता है सेम काम करता है,
बिना मेहनत कर
मेहनत तो सब चीज में लगती है। अच्छा काम करिए चल बुरा।
Item 18 BA 5084 of 2026.
Page 14 is the first information report. When the father lodged his first information report, he had went for attending an invitation, and he alleged that his very petitioner has came to the house and has entered the house and he has tried to give a mobile to his daughter when the daughter and his grandmother were home. Subsequently, he has alleged that his very petitioner is tried to
statement मंगा ले। You are for the information. Counsel for the state is directed to file a contract in this case. Investigation is over.
no. Yes, sorry.
Over. Let the case ID along with its enclosure be called for from the concerned court. Along with the statement of the victim recorded under section 183(3). Pose this case on 14th of July. Contract date should be filed by 13th.
Item 19 BA 5250 of 2026.
This case and the next case arises out of the same equation. So in this case, while hearing a PIL with respect to RIMS, this honorable court passed an order. That order is a part of the FIR which starts from page 29.
Do you wish to file a counter? Required? Not required.
So I can show it from the order. This honorable court protected us. Who are the ultimate? The allegation is that we had purchased the acquired land of RIMS. Now, Your Lordship, it has come to in the order of the honorable High Court that these persons purchasers who are the ultimate victims because of the connivance of the state authorities and the people who propose themselves to be the owners and so on. Lordship,
we are ultimately who lost the land also, we lost our money also. Learned Court below rejected it on two grounds. One ground they say that we are instrumental in initial forgery which was done in 1990. We have given a statement, I was only 12 years of age at that time and I did not even know the seller. And second, you will also take into consideration the direction was
The sale was by registered deed.
by registered deed and after obtaining a certificate from the department that it is not under acquisition.
Yes, ma'am.
And Lordship, the direction was to take action against the state officials, not a single state official has been.
The actual.
No. Let us. They are the purchaser of the property. Yeah, Ranchi ka mamla hai na.
Ranchi ka mamla hai.
They know very well that land belongs to.
Know very well means they are purchasing by registered deed. Know very well means what?
Because
they are making payment.
एक दो केस मेरे पास और है उसमें आया है कि रिम्स का एडमिनिस्ट्रेशन इन लोगों को बोला कि नहीं उसमें कंस्ट्रक्शन करने के लिए
बोलने से क्या होगा?
Because land belongs to RIMS.
From where? Did RIMS file any suit for cancellation of sale deed?
Sale deed and
sale deed cancellation के लिए कुछ किए हैं आप लोग?
वो तो अब केस डायरी में ही आएगा. What development?
Lordship, this honorable court felt that it is a case of corruption. The state officials are responsible. Till date, neither a single state official has been made an accused, nor any of the seller of the lands have been made an accused.
No,
and we are the victim. We are the victim who had purchased the land after.
You are in custody.
Yes, Lordship, I am in custody.
Several government
investigation is complete.
Case diary is not.
आपको पता तो होगा ना कब से custody में?
7th of April 7th of April 2026.
Investigation तो complete नहीं हुआ.
June
It is a case of large.
7th April में जून में हो जाएगा.
नहीं 90 days है इसमें क्योंकि forgery का केस है.
forgery का केस है.
Forgery का अगर definition and judgments देखा जाए तो forgery बोल नहीं सकता. अगर मेरा sale is by a person who has no authority, then also it will not come in the definition of forgery.
We have to see the sale deed also.
And this also.
Mr. Das, it is very important that at least charge sheet तक तो थोड़ा सा investigation के stage में हम.
Actually, my anxiety is if you watch, this is only one paragraph of this honorable court's order. Para 19. That is, if you watch, you will find at page.
Mr. Das, I will adjourn the case till the submission of the state. Charge sheet till the stage of submission of. Because what initial stage है. Allegations are also very serious. पूरा demolition हुआ है.
मेरा demolition मतलब मेरा.
आप ही का property का demolition हुआ है. We appreciate that you are the victim. You are. It appears to be so that you are the victim. Where is the document by which this it was issued that this
yes,
land is not?
Can you come to page 132?
132.
Yes, this is the registered deed. Can you see in the margin? Origin या वन भूमि दर्ज नहीं है. Origin means it is not acquired or it is not a forest land.
No, you said that some certificate.
This is the certificate given. Whenever we put for acquisition, it goes to the office of land acquisition officer's representative, put his signature and seal. Otherwise, we would not have been cheated. And also, Jamabandi is running since 1990. We purchased it in 2022. And that lady who had sold us, she has not been made an accused, and she gave a statement that पूरा पैसा हमको नहीं मिला था. And then on Learned Court below records it and said that she says that she has not got the entire.
Madam, if you want to prepare yourself, I can post it tomorrow. लेकिन यह case diary everything is there on record.
This lady has sold the land, which was obtained by given forced family tree.
Then she should have been made an accused. She has not been arrested till date.
You see, they are buying.
इसका एक केस है मेरे पास उसमें ये भी
नहीं हम तो और भी cases में वो purchaser. You see, it is not what forgery have they committed. What forgery have they committed?
There may be some connivance.
What connivance?
They purchased the land belongs to RIMS. It is a case
Who
of
will-
larger
Who
conspiracy.
will know? Who will know? How would they know that the property belongs to RIMS? By what means they will come to know that the property belongs to him and it is an acquired property? How will they come to know? There is a certificate from the land acquisition authority that this land is not under acquisition. Otherwise, तो deed ही नहीं बनता. They are only seeking bail. Acquittal थोड़ी हो
रांची
रहा
में तो डीड किसी भी लैंड पे बन जाता है.
किसके चलते हैं?
ड्रीम्स का लैंड
Who is responsible for that?
गवर्नमेंट ऑफिशियल्स आर आल्सो रिस्पांसिबल.
तो उनको पकड़िए. जिनका डीड है उनको क्यों पकड़ते हैं इस तरह से?
Only 2 weeks may be granted. अभी तो 3 महीना भी नहीं हुआ है.
कस्टडी तो एक दिन भी भारी है मैडम. किसी का भी कस्टडी एक दिन भी डिफिकल्ट. There is a restoration application also pending.
She filed a restoration application in 1990. There is a finding that there is nothing on record that she belongs to schedule Chikbarai with respect to part of this land. So therefore, restoration is not maintainable and it was given to the LRDC to make an inquiry and hand it over to the rightful owner. But the LRDC conducted an inquiry and handed it over to Sonmay Devi in 1990. And since then, Jamabandi is running in their name. And therefore, Lordship, we could purchase, otherwise we could not have purchased it. There is a finding given by the Restoration Authority that she does not belong to Chikbarai caste. That time also nobody pointed out that it was a acquired land. We verified, we got the certified copy of all the documents, then we purchased this land.
The learned counsel for the parties are present. The petitioner received custody since 7/4/2026 and investigation is going on. There is an allegation against the petitioner that the petitioner has purchased government land which was acquired for use. The learned counsel for the opposite party has submitted that materials against the petitioner is yet to be collected during investigation. She submits that an opportunity to file counter affidavit may be granted. Post this case on 14th of July. Counter affidavit be filed by 13th of July. The case diary. The counsel for the state is also directed to submit the materials collected during investigation against the petitioner, relevant materials collected during investigation against the petitioner in sealed cover before this court. And retain the case diary during the course of court. दोनों केस custody same.
Same district, 17.
Item 21 BA 5259 of 2026.
You get the enclosures also, case diary with enclosures.
For officers under section 3(2) of 3(2) and 13(2) and 13(1)B of Division of Corruption Act. This is a disproportionate asset case in which Commissioner is in custody since 6/3/2026.
How much is the disproportionate?
As per FIR, it is 330%, but charge sheet has been submitted as 6/3/26. Submitted and as per charge sheet, the disproportionate asset is 152% or 152.945, in which the properties of the son, daughter-in-law, son is an employee of HDFC Bank, he has been included. Daughter-in-law is a medical superintendent of BCCL, that has also been.
Both are also working.
Both of them are working. I have annexed their service in payroll, and his wife is income tax paid since 2007, and that is included. May I please charge sheet on page 67?
Just a moment. Did you submit your explanation for the
Yes.
check period? What is the check period?
Check period, as per FIR, it is since check period is since 2005 to 31/12/2005 to 2019, your lordship, and as per
31/12/2005.
5 to 31/3/2019, and in FIR, the check period is in charge sheet gives 11/1/23. Charge.
You were a constable.
I was a constable.
Disproportionate asset of 1.23 crores.
Lordship may see the properties included in.
Yes, what do you say?
Case then called for
Charge sheet, I have annexed the charge sheet.
Whatever my lord may please note the case that.
Charge sheet to be a.
Because he's 61-year-old man has suffered brain hemorrhage and is suffering from heart disease of
The finding of the learned court is there, which is at running page 94, which states that the inventory list of the property of the petitioner is on the record. However, the details of the income of the wife, the son, and daughter-in-law of the petitioner during the check period would not be justified by the petitioner.
They are all working.
He states, my lords,
I have annexed the documents.
plea has been taken by way of referring to documents annexed to the bail petition, as also a supplementary ground for bail as additional documents to establish that the son and the daughter-in-law are working with a multinational company. Lords, I would humbly submit, my lords, that one opportunity to peruse the case diary, and thereafter, if my lords may pass on.
Okay, next Thursday.
Shortest.
Next Thursday. You want to file a complaint? कोई बात नहीं, खाली केस डायरी देखो. The learned counsel for the parties are present. Counsel for the state submits that one opportunity be given to the state to place the materials before this court. He is directed to produce a case diary along with its enclosures, and also submit before this court in sealed cover the materials collected during investigation. So far as he is the only one. Case diary से हो जाएगा, ज्यादा तो कुछ होगा नहीं. उनका explanation तो जो ना जब आपने उनको interrogation किया होगा, तो उन्होंने अपना explanation दिया होगा ना.
As per my calculation,
You see, you must have been interrogated. You must have furnished your explanation, right? Whatever explanation has been furnished, that is the whole very
Yes,
important.
because he states that he has appeared before the police,
Yes,
so that
yes.
has to be not cross-verified.
Verify करके बस. ठीक है? Goes the next Thursday in supplementary causes as first case.
Item 22 BA 5324 of 2026.
Yes, petition. practice? Since when are you in custody?
Yes, I am in custody since 13 years, more than 3 months.
13 to
13 March 2026.
33.
Yes. And similar course has been granted here.
13/3/26.
Yes.
What were you doing? Where is the state?
Peon, I was peon. And
You where?
was in the land acquisition office. And
What is the allegation?
the clerk demanded money for 10,000 from the
For what?
informant.
For what?
For the purpose of compensation, related to compensation. I was peon. He came, was informant and handed over lifafa to me to hand over to the clerk. I handed over to the clerk. This is the date of my retirement of the 13/3 the custody. On that day, I completed 60 years. I have no business to do all these things. I am a peon. I just handed over the lifafa, and allegation is also in the verification.
Charge sheet has been submitted.
13/3 charge sheet submit.
Charge sheet has been submitted.
3 महीना हो गया.
Yes, Mr. Counsel.
और क्लर्क जो पैसा मांगा था, ये has been granted bail.
उसके पास से रिकवरी नहीं होगा ना?
रिकवरी उन्हीं के हाथ हुआ है. हम दिए पैसा, वो जो लिफाफा है, I handed over to him.
No bribe money has been recovered from him. But the same was recovered from his staff. सारा का सारा आपके ऊपर आ गया.
हाँ तो बहस
जो बहस है वही तो बता रहे हैं.
पेज 12 पर देखा जाए इसका तो
आपने कलेक्ट किया, आप ही का ट्रैप हुआ, आप ही का सारा कथा कहानी हुआ. चार्ज फ्रेम करने के बाद चार्ज फ्रेम करने के बाद आइए
खाली पेज 12 एक मिनट देख लीजिए जो वेरिफिकेशन रिपोर्ट.
Page 12.
Yes, that is verification. हम डिमांड ही नहीं किया कि हमको पैसा जा. हम क्या क्यों क्या करेगा उसमें लैंड एक्विजिशन. हम तो प्रोसेस है सर्वर. नीचे बॉटम से 4-5 लाइन हम पढ़ना चाहते हैं बस. आवेदक ब्रह्मदेव यादव ने आरोपी निरंजन कुमार प्रधान लिपिक भू अर्जन कार्यालय देवघर से बोला कि मेरे दिए गए मुआवजा हेतु आवेदन पर क्या कार्रवाई हुई. इस पर आरोपी निरंजन कुमार बोले कि आपको पहले बोले थे कि मुआवजा के लिए मुआवजा राशि का 5% रुपया जमा करना पड़ेगा. आपको 20,000 रुपया जमा करना होगा, तब आपका काम होगा, अन्यथा आपका काम नहीं होगा. आवेदक काफी आर्थिक विनती करने लगे, लेकिन आरोपी नहीं माने. तब आवेदक बोले कि ठीक है, 2-3 दिन में रुपए की व्यवस्था कर आरोपी प्रधान लिपिक से मिलेंगे. उन्होंने मांगा, उन्होंने पैसा लिया, उनको बेल हो गया. हम प्यून है.
अच्छा एक बात बताइए. यस, जो प्रिलिमिनरी इंक्वायरी आपने किया, इसमें इनका क्या रोल? What is the role? You see, there is a direct allegation against the co-accused.
Yes.
There is no role of the petitioner mentioned in the FIR.
Yes.
During the inquiry.
Yes.
Before lodging the FIR.
Yes.
Right?
So
What did you collect?
Yes. At this stage.
At this stage, क्या? वो तो FIR करने के पहले ही किया होंगे ना?
Not only the presumption under 20 of the PC Act is there.
What presumption?
Rather also under 114 of the Evidence Act.
No. What presumption? You see, there is no allegation against the petitioner. The entire allegation is against the co-accused who has been enlarged on bail. आप उनको इतना भी बता दीजिए कि preliminary inquiry में ऐसा कुछ आया. दिखाइए ना.
That he has been caught red-handed.
You see, the money was handed over to the peon to be forwarded to the main accused.
Yes.
Right?
Yes. So
that is the allegation.
Yes.
क्या preliminary inquiry में भी इनके against में कुछ आया है?
He was not the person, but since he has been caught red-handed, conspiracy part cannot be ruled out at this.
Conspiracy का कहानी
Since
कहाँ पर?
it has come from
the person who was demanding the money.
Yes.
Right?
Yes.
As per the FIR, he has been enlarged on bail.
He was in conscious possession of it.
Conscious possession से कैसे चले? नहीं चले. चलिए bail ही दे रहे हैं. Bill number 5324 of 2026. Heard the learned counsel.
What's the name of Mrs. Nehanda Sharmin?
ऐसे नहीं कर सकते. These are online proceedings. हम लोग ऐसे नहीं कर सकते. heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 13/3/2026. And charge sheet has been submitted?
Yes, ma'am.
And charge sheet has been submitted. The learned counsel has placed the FIR before this court and has submitted that the entire allegation of demand of bribe was against the district land acquisition officer.
Clerk, Niranjan.
Was on the clerk, Niranjan.
Yes.
Was on the clerk, Niranjan Kumar, who was demanding money from the informant. He submits that Niranjan, and in the FIR, there is no allegation against the petitioner. The learned counsel has further submitted that Niranjan Kumar has been enlarged on bail by an order dated 4/6/2026 by coordinate bench of this court in BA number 4916 of 2026. The learned counsel submits that the petitioner happens to be a peon and only an envelope was handed over to him, and it appears that only an envelope was handed over to him to hand it over to the accused, to the main accused, who's against whom the FIR was lodged. That's the petition. The learned counsel for the opposite party has opposed the prayer for bail and has submitted that the bribe money was recovered from the possession of the petitioner. Though it is not in dispute that the petitioner was peon in the office of Niranjan. After hearing the learned counsel for the parties, considering the fact that charge sheet has already been submitted and the co-accused against whom the allegation of demand of bribe was made, namely Niranjan Kumar, has been enlarged on bail by coordinate bench, the petition is also granted to bail. Sorry? Madam Nehala Sharminda.
Permission item 23, ABA 7267 of 2025.
Yes, petitioner.
On behalf of PC this is a case in which have heard several allegations. The allegation had not been alleged that not the against the petitioner who was not the.
Who are you? Who are you?
This he had promoted from the post of Karamchari. Now that he has retired. So he was at the time of the alleged offence, he was posted at Karamchari. The case had been registered under section 13(2), section 13(1) of the PC Act, under section 120(d), 420, 447, 468, 470. Now this is a case in which one will find that the mutation was not the made in the name of not the two persons, that is not of the FIR, Vinay Kumar Singh and not the Snigdha. Right, not the mutation case number 481 of 2010-11. But this 2000, this mutation case number 481 of 2010, that's not the 11. But in fact, not the in that not the mutation case, there is no report not of the petitioner. But this is the case we have challenged not from very beginning itself, that not this petition report is not there. Somebody else has made the this report for certificate, hope not the report is there, because the prior to that, this petition was called by the deputy commissioner in a job, and he was asked to give the report in favor of this
Vinay Kumar Singh, that was refused not by this petitioner. Thereafter, Lord, he was, as a punishment, he was transferred from him. No doubt, Lord, in the meantime, Lord, the census, Lord.
You say that the report was forged.
Yes, ma'am.
On the basis of this mutation was done.
Yes, ma'am. That is
And,
not the-
and it does not contain your signature.
Yes.
And that signature is forged.
Yes. Lord, we have also not demanded this document not from the under the RTI. No document not has been given. It can be verified from the records itself, ma'am. Because Lord, now this petition has retired.
When were
on-
you examined by them?
Lord,
When did you appear before them for examination? Because you must have told them that it's a forged document, which is an anticipatory date. They must have issued notice for appearance.
Record not it is written. Now Lord, they are saying.
आप मेरा बात समझ भी रहे हैं, हम जानना चाहते हैं. When you say that the inquiry report contains your forged signature, they must have issued notice for appearance. तो फिर कहाँ से
They are saying, Lord, they are saying the record is not traceable.
Which record is? The
This is not
mutation?
the related to mutation case number 481. They are saying, Lord, because record is not traceable.
तो आप कैसे बोल रहे हैं कि उसमें forged signature है?
Because Lord, I have not stated on both also, Lord, I was asked Lord the Deputy Commissioner to change the report in the favor of Lord the purchaser. Lord, I have refused. Thereafter, Lord, I have Lord the document, Lord, I have annexed
When
that I
were
was
you
transferred.
transferred? When were you transferred?
Lord, I was Lord the transferred. That Lord the in the rejoinder, Lord, I have stated. And
When were you transferred?
and it's a one of the page 15 of Lord the Congress. By memo number, page 15 of the journal. By memo number 692 dated 22/6/2010, this mutation has been done Lord in the month of August 2010.
But the report is prior to that.
Report.
You have been transferred on 22/6/2010.
Yes.
Mutation has been done on?
On 12/8, 18/8/2000.
18/8/2000.
That is added from page.
And what is the date of the report on the basis of this mutation has been done?
No, that is not the, I have not even told Lord, I am not knowing the Lord the date of the report. I have not submitted the report.
In the mutation order, the date of the report is not there.
No, that must be Lord.
So where is that mutation order?
Lord,
Mutation order, that is also not there.
Lord, that is Lord, they are in position of the record. I have retired in the month of, in the year 2016. Now this case has been Lord in the year 2025. Lord, in the rejoinder, I have especially stated all these things. They can be Lord verified. If Lord my report is there, my signature is there, then Lord, I will not record it. Right from very beginning in the main petition also, my Lord.
Yes, Mr. Congress.
And in rejoinder also, Lord, I have stated.
What does it say? These records are not there.
Well, that is recorded in the earlier order also. That after that plot number, if the lordship may see, these records have been missing. I have stated in para 16. The
Destroyed khatiyans of the land.
pardon me, para
Para
16.
16.
Yes.
16.
Yes,
That is further during investigation made attempt to collect the order pertaining to for which inspection report was submitted by petitioner to the sir, who recommended for approval of the mutation to be done in favor and so and so, upon which it reveals that the land records of khata number 95 after bearing plot number so and so was found unavailable in the circle office Sadar Ranchi. But after 773 all dispute starts. So after this it is not available. And land was found to be missing and not traceable. It appears that in conspiracy, so and so with collusion with the circle officer staff, destroyed the khatiyan of the land in question. The aforesaid fact is recorded in so and so. Now, my lord, regarding his transfer, we have specifically pleaded in para 21 and 23, and we have taken a report from the circle officer also. Well, in fact, we have annexed in para 20 his transfer order, which was there in June 2010.
Yes.
Then kindly see, my lord, para 21.
that from bare perusal of the order contained in memo number so and so, it would be evident that although the said order states regarding the transfer of the petitioner from Halka number 3 Shahri and 11 Mauja Baban Bani to Halka number 8 Mauja Daru Harli. However, as per the said order, petitioner was required to submit report regarding takeover of the charge of the transferred Mauja. However, no such document has been annexed by the petitioner to demonstrate as to on which date petitioner has taken over charge of the transferred Mauja. Then further, para 23. We had written letters to the circle officer, Malod, who currently posted that pursuant to the aforesaid letter, a reply was received from the circle officer Hazaribagh by letter number so and so, wherein it is clearly stated and informed that at the time of mutation done on 18/8/2010, officials, namely Santosh Kumar Verma, was posted as Revenue Sub Inspector, Rajendra Prasad Singh was posted as Circle Inspector, and Alka Kumari was posted as Circle Officer at the relevant point of time.
So
and
he
then
was very
kindly
much
see,
there at that point.
yes, then kindly see, my lord, one more paragraph. Paragraph 25. In fact, my lord, this mutation number is 481, and kindly see para 25.
Yes.
He has signed in mutation records for 485, 486, 487, 488 of 2010-11. So 481.
So very much there.
Very much there. And not only that, my lord, we have ladyship, we had already issued him notices for appearance. Kindly see para 27. Sorry, I'll just start from the first.
It is there in para number 17.
Yes, 17 itself. First non-cooperation. 17, yes. First is non-cooperation at para 17. We had pasted it in his house.
Then?
And then para 23 again we have, sorry. I beg your pardon. Para 27. Again non-cooperation in para 27. And one more thing, Your Ladyship, the representation which he had sent to us is at Annexure C, page 23. Yes, Annexure C, page 23. In this para 2, next paragraph, next page starts from para 2, but next page 24. He takes the plea of his transfer first, that I have been transferred, and para 3, he takes the plea that he along with Rajendra Prasad Singh was called by the Deputy Commissioner where Alka Kumari was present, and since he refused, so he was transferred. To the best of my understanding, I could not find anything stated that his signature was fraudulently been done in those records or other things. He has taken the plea of transfer, but not with respect to the fraudulent.
And he is not cooperating.
Yes, he is not
cooperating. Page 24, my letter referred paragraph 3. And this is not very short paragraph.
Sir, the point is that you are supposed to appear once the notices are issued.
My lord, that I have given the reply.
And how your signature is there in the subsequent mutation orders?
My lord, the so far mutation case number 481. My lord, that not the I have simply stated not that I had refused, I had not obeyed the direction of Lord the Deputy Commissioner to give the report Lord in 481 mutation case number. Paragraph 3, my lord, my learned friend just now read. मतलब that is not the that say यह वास्तविकता यह है कि मुझे श्री राजेंद्र प्रसाद सिंह तत्कालीन अंचल निरीक्षक सदर हजारीबाग के साथ मई 2010 तत्कालीन उपायुक्त हजारीबाग श्री विनय कुमार चौबे के आवास पर बुलाया गया। हम दोनों समय करीब 11:30 बजे आवास पर पहुंचे, जहां पर पुरुष सहित तत्कालीन अंचलाधिकारी अलका कुमारी बैठी थी। उपायुक्त महोदय द्वारा हम दोनों नामांतरण दाखिल खारिज वाद संख्या 481 ऑफ 2010-11 का प्रतिवेदन जो आरोपी विनय कुमार सिंह एवं मर्सिदा सिंह के विपक्ष में तैयार किया गया था, उसे बदलने का आदेश दिया गया, परंतु मैंने पूर्व से तैयार किए गए प्रतिवेदनों को बदलने से इनकार कर दिया। साथ ही श्री राजेंद्र प्रसाद सिंह तत्कालीन अंचल निरीक्षक सदर हजारीबाग भी इनकार कर दिए। परिणाम स्वरूप मुझे अंचल अधिकारी सदर हजारीबाग के कार्यालय के ज्ञापन 692 दिनांक 22/6/2010 के आदेशानुसार स्थानांतरण हल्का नंबर 3 शहरी 1/11 मौजा 92 से हल्का नंबर 8 मौजा दारू हरली कर दिया गया। My lord, that I have stated, my lord, I have taken this plea from the very beginning, my lord. That not this is not my report. I have, my lord, refused to change the report. Therefore, my lord, as a punishment, I was transferred. My lord, this fact, my lord, which I have stated, they are also, my lord, relying upon, my lord, this the reply given by the petitioner. My lord, they have paragraph 18 of the counter evidence. My lord, the rejoinder also, my lord, I have, my lord, stated, my lord, I am not running away. My lord, I have filed the reply. My lord, I am not the apprehending that if I will appear before the IU, I will be arrested, my lord. If my lord protect me, my lord, I will say everything. I will cooperate with the investigation, provided, my lord, for some period, my lord, the minors may be stayed. Otherwise, my lord, they are, my lord, blaming me, and my lord, I, my lord, the small prey is being prosecuted in this case, my lord, merely on the basis that record is there, record is not there. Melody, so far, Melody, recent case number 481, 2010-11 is Melody main thing in this case, for which Melody I am being prosecuted. Otherwise, Melody, there is nothing. Melody, they will show the record, Melody. I am ready to give my special signature also for comparing. Melody, I have also Melody filed a Melody petition under the RTA. That has not been given, the record copy of the has not been given. While I have read for the, I have applied for under the RTA. A person, Lord, small prey, he is saying, Lord, the real facts. How
I also missed one more important fact. Sorry, sorry for that. Para 29, we have another case against him where we have registered a PE. And in that PE, my lord, we had found that he has disproportionate asset to the extent of 173.82%. I am really sorry, I missed.
Yes,
Para 29.
Melody, so far, Para 29 is concerned. Melody, the preliminary inquiry is not the FIR. After preliminary inquiry, FIR registered. Melody, I have got no information that any FIR has been registered. Melody, so many preliminary inquiry are conducted. By the Vigilance Bureau, ACB. But there is nothing, nothing has been found against me regarding the DA. Otherwise, the FIR should have been registered against me. Merely on the basis of this fact that it is stated without any evidence that anything was found from the person of petitioner or he was examined. My lord knows that the preliminary inquiry is not there. The FIR is registered thereafter, the person who is made accused can know that he is wanted in their tax.
Third, the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is the Karamchari is the
I also denied your
Karamchari नहीं थे क्या?
नहीं para 26
Revenue sub inspector, public revenue Karamchari.
Okay. The petitioner was the Karamchari / revenue sub inspector / revenue Karamchari in connection with the mutation case number 481/2010-11, in which order was passed on 18/8/2010. And property was mutated in favor of the co-accused, namely Vinay Kumar Singh and Snigdha Singh. The learned counsel has submitted that the mutation, if any, the mutation order itself is based on forged report of Karamchari, in which the petitioner never signed. The specific case is that he was called in the office of the deputy commissioner to change the report which was prepared by him opposing the mutation. But when he refused, he was transferred by memo number 692 dated 22/6/2010. The learned counsel has also submitted that
name of the mutation.
Name of the DP.
Deputy Commissioner Shri Vinay Kumar Chaudhary. The learned counsel has also submitted that the records of the connected records relating to mutation case number 481 of 2010-11 is missing, and the petitioner has been falsely implicated in this case.
But I am not saying, they are not saying that record is missing. But I am saying, that record को copy verify करके ये हमको दीजिए.
Missing.
ये लोग बोल रहे हैं कि
The learned counsel has submitted that as per the prosecution, the records of the aforesaid mutation case is missing, and the petitioner has repeatedly applied for the document under right to information, but the same has not been supplied to the petitioner. He submits that there is no material against the petitioner to connect the petitioner with the alleged offence. He has also submitted that order of mutation was passed after his transfer order. The learned counsel for the ACB has opposed the prayer for bail and has submitted that huge area of land or government land has been mutated in name of private persons, including Vinay Kumar Singh and Sita Singh, at the instance and conspiracy with the co-accused persons, including Vinay Kumar Chaubey and also other office bearers, which also includes the petitioner. The learned counsel then referred to the counter affidavit and has submitted that has referred to paragraph 16 and has submitted that the records of Khatian, Khata number 95, after bearing plot number 1 up to plot number 773 were found available at the circle office, Sadar Hazaribagh, and the land records in respect of the land in question were found missing and not traceable. It is alleged that arising out of conspiracy and land mafia with collusion of deal and circle officers, office staff destroyed the Khatian of the land in question. He then submits that notices were issued to the petitioner to appear by notice dated 21/10/25, 24/10/25, and 28/10/25, and also subsequently by notice by notice dated 16/12/2025, but the petitioner did not appear for recording of his statement. Rather, he sent a reply by stating that the deputy commissioner was pressurizing the petitioner to change the report, and when the petitioner refused, he was transferred. The learned counsel has further submitted that though the transfer order is placed on record, but in spite of best of efforts, the prosecution could not find out as to when the petitioner was posted at the transferred place of posting. He submits that the records relating to mutation case, subsequent mutation cases, that is mutation case number 485, 486, 487, 488 of 2010-11, contain the signature of the petitioner. The learned counsel has then submitted that a preliminary inquiry has been instituted against the petitioner in connection with disproportionate asset. (183) statement है किसका? Mr. Garodia? Who's 183?
Yes, Alka Kumari's 183 statement, para 28.
The learned counsel has also referred to the statement of the co-accused Alka Kumari recorded under section 183 BNSS, who in a statement has clearly stated about the involvement of the petitioner along with the circle inspector in respect to furnishing the inspection report pursuant to which the mutation was done in favor of Vinay Kumar Singh and Stika Singh. After hearing the learned counsel for the parties and considering the allegations made against the petitioner and also the materials collected against the petitioner which has been placed on record through the counter affidavit, and further, in spite of repeated notices, the petitioner has not appeared before the authority for his examination. The records of the mutation case number 481 of 2011 are still missing and investigation is going on. This court is of the view that the petitioner is not entitled to the privilege of anticipatory bail by this court. Accordingly, this application is hereby dismissed.
There are two things will be indicated. I have stated. I have not relying on out of the record.
सर आपके किसी भी सबमिशन को मैंने छोड़ा है लिखने से।
हाँ,
अब नया चीज मत।
नहीं नया चीज नहीं इसी में है। वो तो हम से
नया चीज मतलब जो बहस नहीं की अब नया।
नहीं नया बहस किए कि ये जो नोटिस का था। At that time, Lord, I was ill. I have raised notice certificate. Paragraph 11, Lord, I have stated. And Lord, so far preliminary inquiry is concerned, no FIR.
अच्छा एक मिनट. So far as the preliminary inquiry regarding the counsel for the petition in rejoinder has submitted that so far as the preliminary inquiry is concerned regarding disproportionate asset is concerned, no FIR has been lodged.
That's why it did not appear personal. But he has said would be
Item 24, ABA 7324 of 2025.
Both the petitioner as well as the informant, they are the employees of the same company. Now, they say the company will not be the contractor of the corporation, and the petitioner was appointed as a coordinator for the Lord Kuti. Now, his duty was to be only to see कि कितने आदमी कितने दुकान में काम कर रहे हैं. Requisite कुकी जिला समन्वय विभोर कुमार जायसवाल आधार नंबर 1600 विजन हॉस्पिटलिटी सर्विसेज कंसल्टेंट प्राइवेट लिमिटेड और शराब के कारोबार में मेन पावर आपूर्ति का कार्य कर रहे हैं, जिनके पास वैध प्राधिकारी यानी झारखंड स्टेट बेवरेज कॉर्पोरेशन लिमिटेड है, उनके ऊपर उचित कानूनी कार्रवाई संबंध। मैं सोमनाथ राय चौधरी विजन हॉस्पिटलिटी सर्विसेज कंसल्टेंट प्राइवेट लिमिटेड के डीजीएम के रूप में कार्यरत हूँ, जिसके पास स्वयं है। पेय पदार्थ निगम लिमिटेड राज्य द्वारा कानूनी अधिकार के मद्देनजर शराब के व्यवसाय में शामिल हूँ। महोदय, कुटी जिला के एक व्यक्ति विभोर कुमार जायसवाल आधार नंबर 1600 दिनांक 1/7/2023 को जिला समन्वय के पद पर संविदा पर नियुक्त किया गया था और वो उत्पाद अधिनियम की विभिन्न धाराओं के मद्देनजर सभी परिचालन व्यवसाय करने के लिए जिम्मेवार थे। सर, दिनांक 31/8/2024 को मेमो नंबर 497 गुप्ता अधीक्षक के कार्यालय से इस आरोप के साथ विजन हॉस्पिटलिटी सर्विस के कंसल्टेंट प्राइवेट लिमिटेड द्वारा जमा की गई राशि में अंतर है। कंसल्टेंट प्राइवेट लिमिटेड की राशि रुपया माह अप्रैल 2024 में 30/8/2024 तक 3,83,18,795 रुपया जमा करने का निर्देश दिया गया और अंतर राशि का जांच BCSL के खाते में जमा करने का निर्देश दिया गया। ऐसा नहीं करने पर उचित कानूनी कार्रवाई की जाएगी। महोदय, कंपनी विजन हॉस्पिटलिटी सर्विसेज कंसल्टेंट प्राइवेट लिमिटेड द्वारा आंतरिक जांच में ये पाया गया कि कुटी के जिला समन्वय विभोर कुमार जायसवाल आधार नंबर 1600 सभी गलत प्रथाओं के लिए जिम्मेदार हैं
और इन्होंने दुर्भावनापूर्ण तरीके से कथित राशि का दुरुपयोग किया है, जो कि उत्पाद अधीक्षक अज्ञापन का इतना में दर्शाया है। महोदय, कंपनी के स्थानीय अधिकारी का ये पता चला है कि विभोर कुमार जायसवाल स्वयंसो कुटी ने हाल ही में अन्य व्यवसाय में भी बड़ी रकम निवेश की है, और जब कंपनी ने उनसे पैसे के दुरुपयोग के बारे में पूछताछ की तो उनकी प्रतिक्रिया बहुत ही अव्यवसायिक और असभ्य थी। शिवान से अनुरोध है कि जिला समन्वय अर्थात विभोर कुमार द्वारा पैसे की भारी वित्तीय हेरफेरी को ध्यान में रखते हुए आरोपी व्यक्ति के खिलाफ उचित कानूनी कार्रवाई करे और विभोर जायसवाल के बैंक लेनदेन का बैंक से भी सत्यापित करे और उनके परिवार के सभी सदस्यों का बैंक खाता की जांच करे। हाल ही में विभोर कुमार जायसवाल की पत्नी के नाम पर जमीन खरीदा गया है, उसकी भी जांच की जाए। प्रशासन का स्वयं। Now, not admittedly, that this informant is one of the employee of the company, in which my petition is also one of them. Now, he is the not in charge, he is the DGM, and I am not coordinator. Therefore, now company themselves, your lordship, kindly see, Lord, two documents are very important, Lord. Kindly see annexure 5 at page 29.
I am at page number 23.
My lord.
Page 23.
23. Yes. Yes. विषय के संबंध में कहना है कि जेएसएल द्वारा स्वचालित उत्पाद दुकानों के अप्रैल 2004 से दिनांक गिरफ्तार का कुल अंतर राशि 3 करोड़ इतना रुपया पाया गया है। तो इसी का बेस में जो एफआईआर हुआ तो, और ये पैसा नाउ द कंपनी इज रेडी टू पे द अमाउंट, दे हैव ऑलरेडी पेड 1 करोड़ 21 lakhs एंड दे हैव टेकन टाइम कि हमको टाइम दीजिए, हम बाकी पैसा भी दे देंगे।
कंपनी का लायबिलिटी है, पेमेंट तो करना ही पड़ेगा।
हाँ, तो कंपनी का लायबिलिटी है,
कौन?
मेरा लायबिलिटी नहीं ना, मुझे हम तो खुद एक एम्प्लॉई है, छोटा सा एम्प्लॉई है उस कंपनी का, और ये जो हम पर रिफायर कर रहे हैं, he is a DGM in the company, और entire allegation has been made against him.
He says that the amount has been siphoned.
नहीं, अमाउंट तो कंपनी पर ड्यू है, कंपनी 1 करोड़ 21 लाख दिया भी है, और कंपनी अनडेटेड भी कर रही है।
There is no option, कहीं से भी लाके दे, कंपनी को तो देना ही पड़ेगा।
कंपनी, हम कंपनी है ना, मुझे मेरा पर कोई एलिगेशन नहीं है इसका। You must kindly appreciate this.
Money has been siphoned off.
Siphoned off by whom? By the company, not by the petitioner. वही तो उसको दिखाना चाहते हैं। एक डॉक्यूमेंट जो खाली देखिए, कंपनी खुद कह रहा है कि इन्फॉर्मेंट है, he is responsible for all these things. Kindly see. I'm on page 29. आलोक में कहना है, हिंदी में कहता है,
ये page 26 में you are the person, you were the person to who was
26 में हम कोऑर्डिनेटर हैं, और ये एक्चुअली कंपनी के अगेंस्ट है, ये जितना भी डिमांड है कंपनी के मेरे अगेंस्ट नहीं है, हम छोटा सा एम्प्लॉई है। एक बार मुझे हम पेज 30 जो देखा जाएगा, entire liability has been not casted upon the informant, not against me. Kindly see. जरा पढ़ो।
सेवा में श्रीमान विजय हॉस्पिटैलिटी सर्विस एंड कंसल्टेंट प्राइवेट लिमिटेड प्रतिनिधि कोऑर्डिनेटर महोदय कुटी।
पेज नंबर, सॉरी पेज नंबर
30 विषय कंपनी द्वारा 19/4/2024 के पूर्व दुकान में जो भी घटती उसकी जिम्मेवारी कंपनी के जीएम शंभुनाथ राय चौधरी के द्वारा लिया गया। इस संबंध में महाशय विषय में कहना है कि कंपनी के जीएम शंभुनाथ राय चौधरी के द्वारा एक्साइज ऑफिस में उत्पाद अधीक्षक अवर निरीक्षक बड़ा बाबू कुटी तथा कोऑर्डिनेटर दीपक गुप्ता एवं सभी दुकान प्रभारी के समक्ष जीएम शंभुनाथ राय चौधरी के द्वारा जिम्मेदारी दी गई कि 10/9/2024 से पूर्व जो दुकान घटती है उसका पूरा जिम्मेवार कंपनी वहन करेगी तथा उनके द्वारा कहा गया कि दुकान प्रभारी और सहायक उस घटती की समस्या न रखे और ऑडिटर द्वारा प्राप्त जीरो दुकान के बाद प्राप्त दुकान घटती होती है तो उसकी जिम्मेवारी दुकान प्रभारी एवं सहायक की होगी। आपका विश्वासी स्वयं।
So who has written this letter? Who under whose signature this letter has been?
ये तो कंपनी का है, कंपनी का। और एक बार मुझे 5 भी देखा जाएगा, अनेक्सर 5 HP 29। खुदरा दुकानों के लंबित राशि ऊपरी विषय प्रासंगिक पत्र के आलोक में कहना है कि जोन 5 कुटी में परिचालित सभी खुदरा दुकानों के कुल अंतर राशि 3,83,18,795 पाया गया जिसमें से 1,21,68,445 रुपया विभागीय राजस्व में जमा कर दिया गया, जिसके पश्चात कुल लंबित राशि के एवज में बैंक गारंटी नंबर 1600 जिसकी कुल राशि 99 लाख रुपया है, कंपनी द्वारा बैंक में जमा किया गया है, जो कि कैंसिलेशन प्रक्रिया में है। बैंक द्वारा बीजी राशि जैसे ही कैंसिलेशन की प्रक्रिया 7 कार्य दिवस में समाप्त हो जाएगी, इसके पश्चात की कंपनी द्वारा यह राशि विभाग के राजस्व में जमा कर दिया जाएगा। त्रुटि में आंतरिक अन्वेषण एवं मिलान किया जा रहा है। मिलान के पश्चात जो भी शेष राशि प्राप्त होगी, कंपनी द्वारा 30 कार्य दिवस में विभागीय राजस्व जमा कर। Now, my lord, they are paying the money. The company is paying the money. So far, my lord, petitioner is concerned, he is a simple employee of the company. Therefore, he has got no authority to any monetary transaction. And company themselves.
Were you responsible for deposit of money?
I am not.
Because such responsibility has been given.
The consultation
program body, please find mention authorized representative deployed in Kutti district for attendance, collection, delay, monitoring, new recruitment of manpower in various.
All right.
shops.
चिट्ठी हमको जरूर दिया है, चिट्ठी दिया है हमको, लेकिन कंपनी दे admitting the dues. They are also paying. 1 करोड़ 21 लाख
कंपनी. No option but to admit the dues. Company has to clear the dues. सरकार को थोड़ी पता कहाँ से पैसा आ रहा है।
नहीं, वही तो हम कर रहे हैं। जब कंपनी खुद एडमिट कर रही है कि पैसा हम दे देंगे, 1 करोड़ 21 लाख कंपनी ऑलरेडी दे चुकी है, 99 लाख रुपया हो जो बैंक गारंटी वो भी कंपनी दे चुकी है। नाउ द एंटायर अमाउंट हैज टू बी पेड बाय द कंपनी, नॉट बाय पिटिशनर।
दैट्स
ओनली हो जो एक बात का हम बोलेंगे कि ये जो इन्फॉर्मेंट है, ही इज द डीजीएम ऑफ द कंपनी, वो अपना स्किन बचाने के लिए हम पर एफआईआर कर दिया, कंपनी हम पर एफआईआर नहीं की।
Now, kindly see below paragraph 92 to 102 of the case diary. Various witnesses, including the in charge of the various shops, how they have stated about the involvement in what manner this petitioner along with other persons used to collect the money in cash. Right? 92 to 102. Now I am reading below 192. दुकान के प्रभारी सोमा स्वयं का धारा 94 में उपस्थित हुए तथा मांगी गई दस्तावेज में से एक स्वलिखित आवेदन पत्र के साथ दस्तावेज 7 प्रस्तुत किया, जिसका अवलोकन से पूछताछ के बताया उत्पाद अवर निरीक्षक एवं अन्य के द्वारा दिनांक 26/8/24 को इसके उपरोक्त दुकान का मिलान करने पर कुल 1,31,05,810 रुपये की अंतर पाई गई। अंतर राशि के संबंध में बताया गया कि दुकान में बेचे गए शराब की राशि को जिला कोऑर्डिनेटर विभोर कुमार जायसवाल एवं उनके आदेश पर बैंक खातों एवं कैश के रूप में लिया गया। उसके द्वारा मांगी गई राशि नहीं देने पर विरोध करने पर काम से हटाने व दुकान से दूसरे दुकान में ट्रांसफर करने की धमकी देने तथा राशि का विजन कंपनी के द्वारा राजस्व में जमा कर देने की बात बताया। दुकान के मासिक ऑडिट के समय ऑडिटर प्रकाश कुमार के द्वारा स्टॉक का सही मिलान नहीं किया जाता था, जिससे घटती दिनों में दिन बढ़ता चला गया। दुकान के निरीक्षण में अंतर पाए गए राशि को जमा करने के लिए जब विभोर कुमार जायसवाल से मांग किया गया तो उसने बोला JSPSL के खाता में राजस्व राशि डाल दिया जाएगा, किंतु उसके द्वारा राशि जमा नहीं करने पर हम सब दुकानदारों के विरोध करने के बाद विजन हॉस्पिटैलिटी सर्विस एंड कंसल्टेंट स्वयं शंभुनाथ राय चौधरी जिला उत्पाद कार्यालय कुटी आए और उत्पाद निरीक्षक बड़ा बाबू तत्कालीन जिला ऑडिटर दीपक कुमार गुप्ता के संबंध बैठक हुआ, जिसमें सभी दुकानदारों को जिला कोऑर्डिनेटर दीपक कुमार गुप्ता और होल्डिंग 102 में up to 102 milord, and one criminal antecedent is also there which has come milord in paragraph milord 154 of the case diary. And paragraph 130 of the case diary relates below the bank accounts of all these accused persons, not co-accused persons, including these petitioners. And जो paragraph 22 to 24 of the case diary 3,83,18,75 का जो है ये sorted पाएंगे.
All the learned counsels are pleading on behalf of the parties. The learned counsel for the petitioner has placed their
30.3 का हमने complaint किया है, जो हमको notice दिया था that I have not appeared before the IO and I have complied that. So therefore, we not issue to until का केस जो रास्ता है इसमें.
Financial relating matter में economic.
The learned counsel for the petitioner submits that the has placed the FIR and has submitted that the managing director of the company, namely Vision Hospitality Services Consulting Private Limited, stationed at Gujarat, has filed the FIR against the petitioner alleging
FIR DGM filed here.
DGM. This
DGM. He is one of the employee of the company.
DGM of the
Sampurnam
company.
Rajogiri,
Yes.
Rajogiri, he has filed the company.
That's station at Gujarat has filed the FIR against the petitioner, alleging that the petitioner was appointed as coordinator in the district of Kutti in connection with the business relating to services relating to business of liquor. He submits that there is an allegation that the petitioner has defaulted an amount of rupees 3,83,18,795. The learned counsel submits that the petitioner is a mere employee in the company, and another employee of the company has lodged the FIR against the petitioner to save his own skin. The learned counsel has submitted that the petitioner has been falsely implicated in this case, and the company is now clearing the dues of the excise department to the extent of rupees 3,83,18,795, out of which an amount of rupees 1,21,68,445 has already been deposited. The learned counsel submits that the entire liability is of the company and the petitioner has no role to play in connection with the dues which are payable to the government, and the petitioner has also complied with the notice issued under section 35B of BNSS. 35(3) of BNSS, and therefore the petitioner, having been falsely implicated, he may be extended the privilege of anticipatory bail. The learned counsel for the opposite party has opposed the prayer for anticipatory bail and has submitted that it is a case of financial defalcation. Huge amount has been siphoned off, and as per Annexure 2, the petitioner was the coordinator at Kutti. He has then referred to the materials collected during investigation, paragraph 92 onwards, and has submitted that it has come on record that the petitioner used to collect amount in cash and was supposed to deposit in the bank account, but instead of doing so, he has deposited amount in different accounts, including his own account. He has also submitted that merely because the dues the company has undertaken that to clear the dues of the state does not have any bearing in the matter. He has also referred to the case diary to submit that the petitioner, that another case has been registered against the petitioner, being Lulu, PS case number 18 of 24 dated 7/3/2024.
Now it is not pending.
For
So we
offence
can't
under
get
section,
to compromise.
आपका submission लिखेंगे for offence under section 406/420/467/468/471 of IPC. To this, the learned counsel for the petitioner has submitted that the other case which was registered against the petitioner has ended in a compromise. After hearing the learned counsel for the parties and considering the allegation made against the petitioner regarding defalcation of rupees 3,83,18,795 and the records reveal that the petitioner was appointed as a coordinator in district of Kutti. And also the materials which has been collected during investigation that the petitioner used to collect money in cash and was to deposit in the bank account, and money was deposited in his account and in other accounts. The involvement of the petitioner appears in this case. Further, the argument of the petitioner that the company has undertaken to clear the dues of the excise department is concerned, the same has no bearing in the matter. The dues against the company is anyways has to be cleared by the company, but the petitioner was on the spot collecting, who was required to collect money and deposit. In view of the aforesaid facts and circumstances, this status of the view that the petitioner is not entitled for the privilege of anticipatory bail, accordingly it is hereby granted.
Item 25, AB 1924 of 2026. Item 26, AB 2168 of 2026.
Yes, petitioner.
काउंटर फाइल करना था, काउंटर आज हमको मिला है, काउंटर हमको आज मिला है।
कब चाहिए? कब करना है?
हमको करना है।
बड़ी फिर क्यों सोचे?
काउंटर स्टेट को फाइल करने के लिए बोला गया था, मैं लास्ट डेट में भी नहीं फाइल। आज हमको काउंटर दे दिए, लेकिन सर फाइल वहाँ नहीं कर पाए। कहेगा एसीबी का केस है, इसमें इन लोग का एलिगेशन है, इन लोग के ऊपर
स्टेट नहीं है, काउंटर फाइल नहीं हुआ है, तो हम क्या करेंगे? जर्नी करेंगे।
आ जाएंगे, पास ओवर कर दिया जाएगा।
The counsel for the petitioner is present. Nobody appears on behalf of opposite party. The counsel for the petitioner submits that he has been served with a copy of the counter affidavit. However, the counter affidavit has not been placed on record. Office is directed to place.
In this case, content is ready. Case of Philippians.
If your counsel for the parties are present, counter affidavit has been filed during the court proceedings, which is taken on record. You are there in this case?
Bring it.
Sir?
Okay.
Best करेंगे ना?
I'm not gone through.
Okay, as a not gone through, so कैसे बहस होगा? Let this matter be posted on next Thursday.
Just now given.
At the request of the counsel for the opposite. Case diary इसका? कहाँ है?
उनके पास।
Item 27, BA 3398 of 2026.
Where is the state?
It's CBI.
कहाँ चलेगी? चल रहा है क्या डिस्ट्रिक्ट कोर्ट में?
नहीं, कुछ नहीं चलता नहीं।
चल रहा होगा इंटरेस्टिंग।
नहीं ले सकता।
Interesting court, interesting जगह है, यहाँ चलते रहते। Counsel for the petitioner is absent.
Petitioner is present.
So normally petitioner कभी absent होते हैं, कभी stay. The counsel for the petitioner is present. Nobody appears on behalf of opposite party. Post on next Thursday. In the supplementary list.
Item 28 BA 3422 of 2026.
इसमें लास्ट टाइम एडजॉर्नमेंट किए थे कि चार्ज फ्रेमवर्क ही नहीं, ट्रैप केस का है, 6,000 रुपया है का ट्रैप केस है। चार्ज अभी तक कॉग्निजेंस भी नहीं हुआ है, बहुत प्रयास पिटीशन भी सब जगह दिए लेकिन कॉग्निजेंस हैज नॉट बीन टेकन। ओनली एलिगेशन थे
कस्टडी कब से है?
कस्टडी 20/2/2026, अबाउट 4 मंथ हो गया।
चार्जशीट कब हुआ?
चार्जशीट सबमिट हुआ है चार्जशीट सबमिट हुआ 20/4/2026। कॉन्ट्रैक्ट बेसिस पर था, वो टर्मिनेट भी हो गया, सफिशिएंटली पेनलाइज हो चुका है। इसमें काइंडली ग्रांट ईच एंड एवरी डेट रहेगा फिजिकल पर्सन।
Contractual employment.
Lots.
But where is the opposite party? Or the learned counsel appearing on behalf of the petition. कैसे करेंगे पहले?
पासवर्ड का रिलेशन बुला लो, शॉर्ट
पासवर्ड डेट वर्ड नहीं बना। Counsel for the petitioner is present. It submits that the petitioner is in custody since 20/2/2026. And charge sheet has been submitted on 24/2026. And as per the counter affidavit, prosecution sanction and report of forensic examination is still awaited. He has also submitted that the petitioner was on contractual employment and there is an allegation of demand and recovery of
6,000
rupees 6,000, which the petitioner is alleged to have demanded while working as
रोजगार
sevak. Yes, madam. He submits that the case is not proceeding for want of prosecution sanction. And cognizance has not been taken so far, correct?
Yes.
No cognizance.
नहीं हुआ है ना मैडम prosecution sanction, तो जेल में क्यों रखें? जेल दे रखें। After hearing the learned counsel for the parties and considering the fact that charge sheet has been submitted on 24/2026, but no prosecution sanction has come, and the petitioner was just a contractual employee, and considering the custody of the petitioner since 2026, the petitioner is directed to be involved.
My submission, what is your submission, sanction can be obtained at any stage.
क्वेश्चन थोड़े
Prosecution sanction नहीं आएगा तो ट्रायल कैसे proceed करेगा?
अगर क्वेश्चन का प्रेयर थोड़े कर रहे हैं कि लेटर
It's already charged हो चुका है.
तो केवल बेल
Cognizance नहीं हुआ.
Item 39, DA 3606 of 2026.
7,000 rupees demand है. Just 26 तो 2006 से ये 26 से sanction नहीं आने के चलते अभी तक cognizance नहीं बना.
6/2/2026.
More than 4 months.
काउंटर आया है? काउंटर नहीं आया ना इसमें तो फ्रेश केस.
लास्ट डेट में पूछा गया था कि चार्ज हुआ है कि नहीं. लास्ट 2 केस.
DA number 3606 of 2026. Counsel for the petition is present. Nobody appears on behalf of the opposite party. On the last date, the case was adjourned to find out as to whether directing on the last day the case was adjourned at the request of the petitioner to find out as to whether the charge has been paid or not.
Yes.
The counsel for the petition has submitted that the charge has not been paid so far. Counsel for the state is directed to file a counter affidavit along with the copy of the prosecution sanction if it has been granted. Post on 21st July. The counter affidavit will be filed on 20th.
Item 30, DA 4027 of 2026.
Also allegation under 7A and 12 of PC Act, Lord sir. Other co-accused has been granted bail in this case, Lord sir. So far as allegation against this petitioner is that petitioner, their compensation altogether bride of 40 lakh were demanded by the other co-accused who was the head clerk in the land district land acquisition officer, Lord sir. And for giving the compensation, that bride was demanded by the other co-accused, Lord sir. He has been granted bail from this court on the ground that the lordship so far as compensation.
Who are you?
Lordship, allegation against me is that I
Position क्या था? What was your
मेरे
position?
against allegation I was the middle person of that head clerk, Lordship. इसमें देखा जाए चार्जशीट भी जमा हो गया उसमें सैंक्शन ऑर्डर के लिए पेंडिंग
Recovery.
आपके यहाँ सैंक्शन क्यों नहीं आता है? ऐसे आप किसी को जेल में नहीं रख सकते ना. इतना आपको लोगों को ट्रैप करना है और जेल में रखना है तो सैंक्शन में भी उतना तेजी दिखाइए.
2 चेक भी इनके घर से बरामद हुआ और 5 लाख रुपया
नहीं
काउंटर
इसमें 18/5 को ही चार्जशीट जमा हो चुका है पेंडिंग फॉर द सैंक्शन ऑर्डर.
बाकी सब केसेस में केस डायरी काउंटर हुआ था.
इसमें जो चार्ज
हम बिना केस डायरी काउंटर के बेल
हो चुका है इसलिए और सीरियल नंबर 22 में मुझे अपनी बेल दिए.
आप हमको फोर्स कर सकते हैं क्या? बिना केस डायरी बिना काउंटर देके हम बेल नहीं देते, इसलिए थोड़ा पेशेंस रखिए उसके बाद ही देते.
That I consider, but only thing is that who accused who is having main allegation has been granted bail from this honorable court.
बाइंडिंग है ऑर्डर मेरे ऊपर.
बाइंडिंग
किस तरह का बहस कर काउंटर की या फिर रिजेक्ट नहीं कर रहे काउंटर की भी. आप क्या थे वहां पर लैंड एक्विजिशन? What was your position?
I am the private person also. There is an allegation against me that
no
I am the middle person. I am the middle.
No requirement of sanction.
I am the middle person of that land acquisition, that head color of land acquisition officer. But that is the allegation against me.
देखते आपके यहाँ से क्या रिकवरी? चेक रिकवरी हुआ आपके पास?
चेक मनी ऑल्सो.
प्री ट्रैप मेमोरेंडम में 2 वर्जन है. जो मेन एक्यूज है वो एक्यूज उनका हुआ है कि 5 लाख
number
रुपए.
4027 of 2026. Counsel for the petitioner has submitted that 2 accused persons have been enlarged on bail. One accused person has been enlarged on bail. However, this court is of the view that Counter affidavit is required in this case. Counsel for the state is directed to file a counter affidavit. The counter affidavit should be filed by 13th of July, post on 14th. नहीं 14th को तो नहीं आ सकता, Thursday को है. एक केस में कर दिए हैं, जिसमें कर दिए हैं कोई बात नहीं. Thursday उस वीक छुट्टी है. Counter affidavit be filed by 6 July तक कर दीजिए. Post on 9th of July in the supplementary process.
Password case item 7, BA 5049 of 2026.
Yes.
Please under section 301
Who are you? Who are you? आपकी आवाज तक नहीं पहुंच रही. Who are you?
The named accused person of Maro. Allegation and
Read the
petitioner
FIR.
Maro is cooperated the other accused persons who
Read
committed.
the FIR.
Yes. श्री निवेदन पूर्वक कहना है कि मैं 10वां न्यायालय उम्र 30 वर्ष इतिहास वर्गीय दिनेश टीयू किताब छुटा होना चाहिए भाषा के मेरी शादी वर्ष 2014 में मेरी माँ बाप और भाई दिव्या टीयू दुबई में रहते थे. करीब 2 महीना पहले अप्रैल माह में मेरे पिता की मृत्यु लंबी बीमारी के कारण हो गया था. कल दिनांक 6/6/2023 को सुबह करीब 9 बजे मेरे भाई ने दवाई और बहन पुलिस ने फोन से खबर की कि मेरे माँ नामसी हुई का गला काटकर हत्या कर गमरिया गांव के पास खेत में शव पड़ा हुआ है. मैं जब गमरिया गांव पहुंची तो देखी कि मेरा भाई दुबई और 15 साली थाना की पुलिस पहले से पहुंची हुई है. इसके बाद मेरे और भाई के सामने पुलिस
Counter आया है. Counsel for the state is directed to file a counter affidavit in this case. आप कब से कस्टडी में?
हम कस्टडी में हुजूर 8/6/2023
Let the case diary be called for from the concerned court along with the present status of the case. क्या status है?
3 विटनेस जामिन हुआ हुजूर और
Counter affidavit be filed by 13th, post on 13th. ये Thursday को हो गया. ये PC Act वो नहीं है, PC Act नहीं. Notice to informant. Counsel, you serve notice to informant. State to serve notice to informant.
Item 8, BA 5050 of 2026.
Implicated in a case registered for the offence under section 107 of BNS, which is corresponding section of 306 of Indian Penal Code. As per the allegation, father has registered FIR, he was not known, and subsequently he come to know that the daughter has went to her forest and has committed suicide. He has alleged that there was a love affair between the petitioner and the informant since last 1 year. And subsequently, and there is talking term between both the post of that. There was some talk.
Love affair between the petitioner and the informant.
Deceased. Daughter of the informant. And therefore she has committed suicide. There is no allegation that any abatement on the part of the present petitioner, save except that there is love affair. He is also issued there was some video was viral. In that year 1 year, but there is neither it has been recovered nor brought on record. Only thing while his statement.
Counsel for the state is.
And his statement has
Just
been.
a moment. Counsel for the state is directed to file a counter affidavit and serve notice on the informant of the case and also produce the report from FSL launching in seat cover before this one.
FSL with respect to the FSL, there are
FSL ही आपका connecting link आप produce करिए.
FSL वो सर्विस नोटिस साइट के उसमें तो कोई कनेक्शन नहीं है और मोबाइल
FSL report से पता लग जाए. आने दीजिए FSL रिपोर्ट,
FSL रिपोर्ट आया नहीं है।
आ जाएगा ना।
इसमें विक्टिम को नोटिस
हाँ, विक्टिम को नोटिस करिए, काउंटर एफिडेविट फाइल करिए। The counter affidavit be filed by 13, post on 14th.
कन्वर्सेशन था, इट इज नॉट इन दिस, इसलिए वो आएगा ही, कन्वर्सेशन था 400
FSL में वहां से कुछ मटेरियल कलेक्ट होके भी गया होगा ना, प्लेस ऑफ अकरेंस।
वो तो सुसाइड है, इसलिए
We do not know.
400
I am really at loss कि FSL में चल क्या रहा है। 3-3 साल पुराना केस का रिपोर्ट नहीं जाता है, मतलब हमको समझ ही नहीं आता है, मतलब what is the state doing? बताइए।
FSL रिपोर्ट मिला होगा, उसको लेट कर रहा है।
लेट का बात नहीं है, वो नया वाला सैंपल भेज देते हैं टेस्टिंग के लिए, टेस्टिंग के लिए नहीं शुरू करते, टेस्ट दे डू नॉट कमेंस। एक रिकॉर्ड में आया है 2 साल बाद बोले कि आपका जब ऑर्डर आया है देन दे हैव स्टार्टेड द टेस्टिंग।
सही लगता है कि प्रिजर्वेशन सही है कि नहीं, क्या
यू आर डिस्ट्रॉइंग, यू आर पार्टिसिपेटिंग इन डिस्ट्रॉइंग द एविडेंस, इसीलिए एफएसएल रिपोर्ट मंगाते हैं। अभी जब कलेक्ट किए हैं तो these are in rape cases, in these kind of cases where there are circumstantial evidence,
yes,
these are important evidences. अब स्टेटमेंट ऑफ विक्टिम के बेसिस पे आप कन्विक्ट कर दीजिए, पता चले एफएसएल रिपोर्ट में किसी और का ही रिपोर्ट आया हो, देन विक्टिम के लिए, पिटिशनर के लिए भी तो सही नहीं है ना।
Also with item 11 DT.18.07 of 2026.
In case of cybercrime, there are 10 persons who were arrested. 9 of them has been arrested.
What is this idea for?
That was for ignoring the defect.
That has been done.
All the defects have been done.
This time, any antecedent?
Your Lordship,
What has been recovered from you?
One mobile phone with SIM.
One mobile, one SIM. Yes, ma'am, what do you have to
Your
say?
Lordship, there are several e-wallets calculated and false SIM card were used. in the time.
How many victims?
In Pratidin, there are some victims. In Pratidin portal, the portal is there in Pratidin. There is a case has been instituted against in Pratidin also. And then
FIR, counsel for the state is directed to file a counter affidavit in this case, along with the criminal antecedent report of the petitioner, indicating as to whether any other case has been lodged against the petitioner in the state of Jharkhand or outside the state of, or in other states, depending upon the materials collected during investigation and the complaints which might be available in the portal. Post on 7th. Counter affidavit will be filed by 6th. Okay? And produce a case diary. The case diary be submitted to the court on 6th.
Item 14 BA5070 of 2026.
The offence under section 304B, that is equivalent to 80 and 3534. The petitioners are parents only. So far, none of the law is concerned, she has been granted by this one called regular court in acceptable. The education note is that Bingla Devi is the informant. Her daughter Sumitra was married with Shivam Mehta. Then there was education note, general education against
Where
all.
is the husband?
Husband is interested. Now, Lord, in this case, Your Lordship, I have mentioned that after investigation, police
FIR
charge
produce.
sheet-
Can
charge
you
sheet-
read the FIR?
Yes. Charge has also been framed on 9th April 2026. Your Lordship, may kindly see page number
Can you read the
13.
FIR?
Page 13. No specifically. Page
Can you
13.
read it?
The such and such Shivam धार्मिक स्थल में शिवम मेहता पिता सचिन साथ के साथ हुई थी। शादी के समय दोनों पक्षों के लोग उपस्थित थे। शादी में दहेज के रूप में नकदी 3,21,000 रुपया, साथ में 1,65,000 करीब अन्य घरेलू सामान दिया था। 14/7/25 को 5 बजे मोबाइल के से पता चला कि मेरी पुत्री सुमित्रा कुमार पति शिवम कुमार मेहता की मृत्यु लक्ष्मी बागी अटका में हो गई। शादी के बाद पप्पू मेहता पिता सचिन सच के साथ सुमित्रा की सास मुनी देवी पति सचिन सच के पुत्र शिवम कुमार मेहता एवं पार्वती मुसम्मत पति सचिन सच ननद खुशी कुमारी को एक मोटरसाइकिल की मांग करने के लिए कहने लगा। यह बात मेरी लड़की ने मुझे बताई। हम बोले कि गरीब आदमी है, शादी का कर्ज जमीन बेच कर किया है, हम नहीं दे पाएंगे। उसके बाद पांचों परिवार दिन हमारी लड़की से गाली गलौज मारपीट में प्रताड़ित करने लगे। इस सिलसिला नित्य दिन का हो गया। खुशी कुमारी पति पवन मेहता ग्राम सचिन सच के साथ शादी हुई है। यह अपने मायके लक्ष्मी बागी में रहकर घटना के अंजाम दी, जिसमें मुझे पूर्ण विश्वास है कि मेरी पुत्री सुमित्रा का हत्या गला में रस्सी से पांचों ने दबाकर कर दी। पप्पू कुमार सचिन।
Now the postmortem report I have also referred in my petition. It is not expressly due to hanging, no external or internal injury found.
Within 2 months of marriage.
Yes, 2 months.
Within 2 months of the marriage. So far, one of the co-accused, Kushi Kumari, has been granted bail, regular bail by this court, that is an exception to page 16. The petitioners are parents-in-law. They are in custody since 15th July 2020, about a year, 11 months. I have also mentioned in para 20, the 9th of April 2026, charge has been. No prosecution witness has yet been examined.
The learned counsel further stated directed to file a counter affidavit in this case. Let notice be served and also serve notice upon the informant. The case diary along with its enclosure, including the inquest report and the postmortem report, be called for consent. The counter affidavit will be filed by 20th of July, post on 21st, along with the stage of the case.
Yes.
Okay, सबका काम?
Also, Item 25 ABA 1924 of 2026.
Yes.
Yeah, please.
Where is the other side?
Fire starts at page. This counter affidavit will file by state. The fire starts at page 17. The prosecution story is at page 20. Yes, come on. Allegation is with regard to withdrawal of 9 crore rupees, which was for the Jharkhand State Electricity Employees Master Trust Fund. Petitioner is not named in the file. The petitioner has come on the basis of confession recorded of this confession recorded in one other case, as well as that of co-accused. He is neither the employee of Master Trust nor an employee of bank. But the only material against this petitioner is that the self-incriminatory statement recorded in other case and that of co-accused person. But counter affidavit has been filed.
Case of the co-accused has been rejected.
Case of my information report, I have got one order which was dismissed as withdrawn from this report. He happens to be employee of one of the employee of the bank. Case of this petitioner is entirely different. He is not an employee of either the bank or the electricity master trust.
Now this person has been enlarged on me. After withdrawal.
No, but he's some other person which was withdrawn from this only.
But thereafter it has been withdrawn, he has been granted bail. In that list, his name is also there. In that list, 24 cases, his name is also there.
24 cases.
Look at 9/32/2026 and his name also.
You know, since this case was withdrawn, my lord, since that person is named as an accused in FIR itself, and he happens to be employee of the bank.
Are you there for the state?
Yes.
In this case?
Yes. But I'll place the counter affidavit also.
That's all. Post tomorrow.
Thank you.